going to have to tell you, please speak directly into the microphone. That's speaking directly to the burner. So if you're off to either side, she may not hear you. If you start to speak directly into the microphone.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. Our third, Judge Benjamin and I in particular want to welcome Judge Berner, who is in Baltimore and on the video. And we look forward to Judge Berner's our most recently appointed judge on the Fourth Circuit Court of Appeals, and she's participating remotely today from Baltimore. And at any point in time, Judge Berner, if you have questions of these lawyers of any nature, if you have trouble getting our attention, hold up your hand, and I'll keep my eye out, and we'll recognize you. We look forward to the arguments of interesting cases from good lawyers. And with that, our first case is United States versus Bullis. It's an appeal from the Eastern District of North Carolina. And Mr. Brignac.
Yes.
Of the Public Defender's Office.
Yes,
Good
sir.
to have you with us, sir.
Thank you, Judge King. Great to see you again. And yes, Eastern North Carolina. Very proud. So may it please the court, I am Eric Brignac for Stefan Bullis. And this morning, I want to address two errors that the district court made. First, it increased the sentence on counts that Mr. Bullis had already fully served in violation of double jeopardy. And second, it violated this court's rule in Rogers and Singletary by issuing a written judgment that contained conditions of supervised release that were not part of his sentence. And I'm planning to start...
Those are both sentencing errors you're claiming.
Yes, Your Honor, because it was a resentencing.
And your client had a life sentence.
He did. He had 2 life sentences on the 924C counts that were...
2 life sentences for sending bombs into his wife's workplace.
Oh, yes, Your Honor.
I understand.
A
That was
horrific...
back in the 90s.
A horrific crime for which he has great regret and for which he has served an extraordinarily long sentence.
In 1996, I think he was sentenced.
Yes, he was in for 331 months at the time of granting the motion dismissing the 924Cs.
I'm just trying to put it in the context a little
Yes,
bit.
a horrible crime, a long sentence,
Let me say, we deeply appreciate your work in cases like this, and we very much appreciate having you here on
Thank
this
you.
point. But sure, there were some Supreme Court cases, in our cases too, that changed the sentencing laws a little bit, and as a result, he got a chance to get a resentencing.
He did, Your Honor. He got a resentencing after the 924Cs were vacated. So again,
924C relates to sending these bombs in packages.
Exactly, and you know, it was
Vice workplace.
categorically, I mean, they're not really relevant today, but I agree background is good. Categorically, the arson crimes were not crimes of violence for purposes of 924C, and so that's why we're here.
That's why we're here.
He was resentenced on the other counts.
He had life sentence, so those life sentences were vacated.
Yes, sir.
And he was resentenced, and you're claiming that resentencing violated the double jeopardy clause of the Constitution.
Two claims, Your Honor, exactly. And, you know, I can start with the double jeopardy. If this court were to agree to a Rogers Singletary remand, I could also see prudentially under constitutional avoidance. You know, if we win on Rogers Singletary, we get a full resentencing, so we may not address double jeopardy. But I do think the double jeopardy claim was plain error. Silvers...
So you're talking about Ashwander.
Constitutional avoidance? I don't know if I'm...
Remember the old Ashwander case?
I unfortunately don't, Your Honor. If I'm...
Well, that's a Supreme Court case.
Okay. Well,
On constitutional avoidance, that's where
Yes.
it all came from.
So-
If we can decide it on a non-constitutional basis, we do that.
And exactly, Your Honor. So I'm saying that may be what this court does, depending on how this court sees the merits of the Rogers Singletary resentencing.
Why don't you argue that second issue first? I mean, I
Yep.
just...
Nope, yes.
We don't want to decide constitutional questions. We don't have to.
I am here to answer the court's questions, and I think we raised
How's
two...
it double jeopardy anyway? He had a life sentence.
It is double jeopardy under Silvers, Your Honor.
So he hadn't served the life sentence.
Well, and that...
So he was resentenced. So it can't be double jeopardy. The common sense it doesn't anyway.
Well, and I think the argument Your Honor is making, I think, can be described as the sentencing package doctrine, which was addressed and rejected in Silvers. So that's our argument there.
Where's the Silver's case come from?
From this court, 1996, Your Honor, and it was a very similar situation. A count was vacated, just like we had a count vacated.
The government's going to say that doesn't control.
Of course it is, Your Honor, and that's why we're here.
Well, we have Smith too now, 97.
We have Smith.
And I think the argument is that Silvers is different in that in Silvers, this whole notion of expectation of finality, and that your client did not have this expectation of finality because of the total sentencing. And that when we send it back, when it goes back to the district court under the sentencing package, that the district court has to go back through 3553A and look at the entire sentence.
I think that is a very good articulation, Judge Benjamin, of the government's position. And I would say, I guess my strongest counter to that is that if you were to have applied that rule in Silvers, Silvers would have come out differently. And Smith lacked the power as a panel of this court to overrule Silvers. And so that's our strongest argument. I wish
This three-judge panel can't overrule that three-judge panel.
Yes, and
Is that right?
Judge Berner, I think, has a question, Your Honor.
Go ahead, Judge Barner.
Thank you. So, Mr. Bigneck, I don't actually agree with you that Smith conflicts with Silvers. In Silvers, the sentences ran concurrently. So they were independent of one another and began at the time of his incarceration. But in Smith, the sentences ran consecutively. And so we had to think of them as a package. Why doesn't this explain the distinction between the two cases, Smith and Silvers, and allow them to coexist? I think it's incumbent upon us not to find that one panel decision conflicts with another, where we can read the two together and not in conflict with one another. And I see the distinction between the two as that one concerned a concurrent sentence and the other concerned a consecutive sentence. Is that not really the difference here?
It is not. I don't think, Your Honor, that is not the reasoning on which the Smith court relied. So that could be a distinction. And, Your Honor, I also understand, just to be frank, I am up here on plain error. So the fact that we've gone about 6-7 minutes now and haven't come to a clear resolution means I may, under constitutional avoidance, jump to my second question. I always understood being here on plain error was a bit of a heavy lift. And I think in terms of the Roger Singletary error, we allege two of them, and I think the second error, the search condition, I think I can give an example that will clarify why that is not just, as the government would say, a mere clarification. In his sentence, his oral sentence, it says, to supervise you, we can search your house, your car, data collection devices, etc. Doesn't say papers, doesn't say effects. The written condition purports to say we can search any house.
Report, it says what it says.
It says what it says what it says. I guess I'm saying it's not his sentence. Any house, any residence, any vehicle to search your effects. So the example I'd like to give this court is, what if Mr. Bullis had a box, a suitcase that he put in a bank safe deposit box? Under his sentence, that would not be searchable. It's not an electronic device, it's not his house, it's not his car, and obviously an extraordinarily high subjective expectation of privacy. Under the written judgment, yes, Your Honor.
Didn't the district court, identify that there are standard terms for the district and then tell Mr. Bullis that he would comply with them? And don't those standard terms include the and effects language?
And Your Honor, that ties into, I would have to relook at those standard terms to see if it has the effects language. I would have two responses even if it did. First, as you know, our first argument is that she did not actually incorporate or impose all of those standard conditions. She only incorporated or imposed the ones that she enumerated. And secondly, even if she mentioned that, even if this court disagrees with us on that first issue, by then specifying a specific search condition, the specific would trump the general. So even if effects is in that standard list, and I will go back during rebuttal time and get that exact language, I think any confusion on that point, any reasonable defendant would say the search condition she imposed is the one she announced. And under that condition, again, my example, if he has a suitcase, if he has a bag, if he puts it at the bank, if he puts it at his family member's house, under his actual sentence, the orally announced sentence, probation could not search that without a warrant. Here, probation officer could come up to him and say, Mr. Bullis, let's go to the bank, get your key to the safety deposit box, and if you don't let me in there, I'm going to send you back to jail. So that is not just an extra word. That is not just a clarification. That is
It is just an extra one word, and there are two words.
Two words.
Two words difference, you're saying 2 words difference. Makes the entire difference.
Makes the entire difference, right. So I guess what I'm saying, to be more precise, one word can make all the difference. So I think the government will say, oh, it's just the word effects, it's just this add-on. But in terms of the real world effect.
And you're talking about the difference between what the judge said from the bench and what the clerk's office probably wrote in the criminal judgment.
And
That's a hard market.
Yeah. Well, and it's the difference between what he was sentenced to while he was present and what was written in that judgment. And I think, and I'm not behind the scenes, I don't know how these judgments are actually physically produced, but you do bring up a good point, Judge King. This is not a...
I don't know how they're produced in every courthouse, but I have some experience with how they're produced where in I practice law. And I think they were pretty much produced in the clerk's office. The next day, probably, or the day of the sentencing, and they were written up and filed what happened in the courtroom. And the discrepancy, that's where the law came up. You had discrepancies between these written criminal judgments and what was said in the open court. And people have gotten relief on it. But this was, you're talking about hanging your hat on one word. You're stretching this thing, and they're trying to stretch the thing, seems to me.
I guess I want to bring up, Your Honor, just how easily, because I think your question sort of gets to this, how easy this would be for a district court to get correct. However it's done by the court within
They try to get correct.
They do, Your Honor,
certainly
but...
try to get correct, and the lawyers, like yourself, and the government are asked to help them. I remember, you cited that Smith case a few minutes ago, correct?
The Smith case, yes. In our
The
first...
recent one.
Oh.
Talking about the recent Smith
Oh, yes,
case?
Smith, yes, Smith
The
v.
one I read.
Alcorn. Yes, Your Honor.
There's a footnote in there about the judge asked the lawyers, is there anything else from the bench? And they both said no.
And
then they came in and complained that the judge didn't do it right.
And, Your Honor, I would say...
I mean, the lawyers have a responsibility, too.
And I would say two responses, Your Honor.
Maybe the government has more than you do even, but you're an officer of the court, too. I'm talking about you in the context of defense lawyers.
Your Honor, the error did not occur until the written judgment was issued. So this was not a situation where, say, the district court imposed a condition, said something that was ambiguous, and perhaps there's an argument the lawyer should have asked for clarification at the time. The moment the error occurred, it's when it appeared on the docket, not a second before, and at that point, it's too late. That's why we're here de novo, and that's why we're not here on plain error.
Does harmless error apply in that situation? It does.
No, Your Honor.
Under Rule 52, it applies. Harmless error. Every error has to be prejudicial.
I've never...
Every error under Rule 52 of the criminal rules has to be a prejudicial error before you can get any relief. So non-prejudicial errors are not to be recognized. That's what the rule says.
The fact that Mr. Bullis, upon pain of reincarceration, is subjected to a condition that he was not sentenced to is prejudicial, Your Honor. I think part of the reason Rule 52's never come up in this context is if it's not...
But it still has to be reviewed for harmless error.
And
It's a non-constitutional thing. You said that.
it is.
All right, and you said that, and so it has to be reviewed for harmless error. And this is a guy that tried to blow up his wife and got a life sentence. We know what the facts are in the case.
Judge Berner, I saw you raise your hand.
Yes, thank you. The government argues, and I think my colleague Judge King is getting to this point, that the as effects language is to those two extra words are simply clarifying what the district court pronounced at sentencing. Why should we not agree with that?
Because, Your Honor, in the context of the announced sentence and the written condition, we see how broad effects are. Because if you look at the actual orally announced sentence, Joint Appendix 579, 580, it's limited. Your car, your house, your person. So there is a limitation to him. But then if we look at Joint Appendix 289, the written judgment, any property, house, residence, vehicle, and your papers and effects. So it is, in that context, much broader. The government says, look, if we can search his house, we can search anything in that house. True. I don't disagree with that. But this is broader. This is if he puts some effects at a friend's house, in a safety deposit box, in a family member's house. So as this court knows, we read everything in context. And in context, this is broader than, hey, we can search your house. We can search everything in it. We can search anything you own anywhere in the world. It's different in kind. That, Your Honor, is why it is not harmful. I see I have 4 seconds left, so if there are any more questions, I'm happy to answer. I see you on rebuttal. Thank you.
Judge Barnard, any further questions? Thank you, Mr. Bricknell. You saved some time, too.
Thank you.
Ms. Englander, good to have you with us.
Thank you, Your Honors. May it please the Court. My name is Kate Englander, and I represent the United States. The District Court did not...
You're an assistant United States attorney in the Eastern District of North Carolina.
I am, Your Honor, yes.
Good to have you with us.
Good to be here. Thank you. The District Court did not plainly err in resentencing Stefan Bullis to 450 months on the remaining counts of his sentence for mailing pipe bombs to his wife. I'm going to first address the double jeopardy issue. The sentence did not violate double jeopardy. In fashioning that sentence, the sentencing court relied on this court's binding precedent, United States versus Smith.
Well, of course, he brings up Silver, so tell us what is distinguishable between Silvers and Smith. He seems to think that Silvers is the controlling precedent and Smith is not.
Thank you, Your Honor. I want to address a couple of points about the tension between Smith and Silvers. First, I think it's important just to recognize that Smith is decided less than a year later than Silvers. And the court in Smith directly addressed Silvers in its opinion. It reckoned with that case. It addressed what it thought to be the principal holding of Silvers, which is that once a sentence is fully discharged, double jeopardy does attach. But what it said was Silvers doesn't directly address the question of when is a sentence fully discharged. And Smith answers that question by saying it is not fully discharged until all of the component parts of that sentence have been fully served.
And in Silvers, and I think Judge Barner kind of alluded to this earlier, whereas here, and I guess and also in Smith, in Silvers is his concurrent sentence, right? And if I recall correctly, he had served the 5 years, which was a statutory maximum on the, I think it was a fraud and a drug charge, right?
That's right. So, and I think another part of Silvers that's important, and this is really in response to something raised in the opposing counsel's reply brief. In Silvers, the government actually conceded that the defendant had already served 7.5 years. The government conceded that it was error for the court in Silvers to have revisited those 5-year concurrent sentences. So to the extent that Silvers is addressing that question, it wasn't really raised by the parties. The government and the defense in that case both agreed that the court erred in revisiting those 5-year sentences.
Yeah, and in essence, basically, I think in Silver's they were not giving him time served by the time that he served. He was going to start a new sentence, a completely new sentence.
That's right, Your Honor, and that was not the case in Smith, and it's not the case here.
Okay.
In Smith and in this case, if the court were to find that double jeopardy, the resentencing violated double jeopardy, the defendant would just be released. I want to address a couple other points about Smith, because I do think opposing counsel is correct. This is plain error. So to the extent that the court erred in following Smith as opposed to Silvers, if there is a tension there.
Now, which Smith case are you talking about?
I'm talking about United States versus Smith from 1997, Your Honor.
Earlier there, I was talking to your colleague, I was talking about a Smith case that came down in the last 30 days.
Okay,
There's a lot of Smith cases.
Understood. It's a common name.
Yeah.
What I'm referring to is Smith, which is what we contend is the binding precedent on
The
this
old
court.
Smith case, not
Yes,
the new
sir.
Smith case.
Probably not the oldest Smith case, but at least
Not the
an
oldest.
older Smith case. And I think it's also important that this court, in a couple of unpublished opinions in 1997 and 1998, recognized itself to be bound by Smith, not by Silvers. And in one of those cases, United States versus Butler, again, it's an unpublished case from 1997.
Well, we aren't bound by those either.
I understand, Your Honor, but I think it's important for this reason. One of the panel in that case was composed of Judges Russell and Hall, who were also on the panel in Silvers, and they did recognize that they were bound by Smith to the extent that there was a tension
Those are
between.
very able judges, I'll tell you that. One of them was my direct predecessor.
I'm sure that's true. I also, and this is really goes more, I understand the court's not bound by it, but it does go to plain error. The district court, to the extent that it followed Smith in error, that error was not clear or obvious because this court itself has recognized.
Now, where's plain error come in here?
So it comes into.
On that sentencing stuff, we pretty much settled that, didn't we?
Yes, so the government's position is that it was not error at all. But to the extent that there was any error, it's not plain because to the extent that this court believes that the court should have followed Silvers as opposed to Smith, that is not clear from this court's case law. And it's also, I'll just point out that other sister circuits that have addressed this issue have also found that a sentence is not fully discharged until the component parts are served, including the 1st, 2nd, 5th, 6th, 7th, 8th, 9th, 10th, and DC circuits. And those courts, to the extent that they've looked at this court's precedent, have found that this court, that the precedent is Smith and not Silvers, that Smith is the controlling case. That's just, and again, this.
I want to go back to something you said earlier because you said that if we found that the sentence violated double jeopardy, then you said Mr. Bullis would be set free. But I don't think that's right. If we found that this was in conflict with the double jeopardy clause, wouldn't the answer be that he would be sent back to the district court for resentencing?
No, Your Honor. So on the remaining counts in this case, after the 924Cs have been vacated, the highest sentence the defendant was given on any of the remaining counts was 240 months. He's already served more than 240 months. And again, we don't think we think that the defendant was sentenced as a package. He didn't have an expectation of finality in his sentence because he was initially sentenced to life. And so the court could revisit the entire sentence when it resentenced him.
And his aggregate sentence now is 450 months.
That's correct, Your Honor. So
And he served altogether 300 and some of that.
That's correct.
We've got about 100 months to go.
That's right, Your
You
Honor.
know.
So what you're saying is he would be sent back for resentencing, but the sentence that he served would have been found to have been completed.
That's right. So if the court, if this court finds that it violated double jeopardy for his sentence on count 2 to be increased from 240 months, which was the initial sentence, if that violated double jeopardy, then he has served fully the only sentences that would be remaining. And so, Your Honors, again, I think it's also important to recognize that the sentencing packaging theory has been embraced by this court in other contexts. Earlier this year in United States versus Richardson, this court in a First Step Act case found that it was appropriate when that sentence was sent back for resentencing for the court to revisit the entire package. That's consistent with what this court has said about the broad discretion of the district court to fashion an appropriate sentence. And it also, this court has recognized that that is in line with the way that district judges practically make their sentences. They don't look at it count by count in a vacuum. The counts aren't siloed. They look at what the overall effect on the defendant would be. That's consistent with what the statute requires, how the guidelines look at relevant conduct. And so we believe that Smith is also correctly decided.
So let's talk about this word effects. Counsel says that it's broad, it expands, that it expands the conditions, and I think your argument, and Bruce, is just that it clarifies it. Why? I mean, tell us why it's not broad, why it doesn't expand, because effects is a pretty broad word.
Yes, Your Honor. So when the court imposed orally at sentencing that condition, it described the places that that could be searched. Effects just clarifies that within those places that the court is ordering the defendant must submit to search, that it can also search effects within those areas. So our position is that defense hypothetical where there's a safety deposit box, that would not be covered by either the judgment or the oral pronouncement. So really, effects is just clarifying what within the locations that the court has ordered him to subject himself to search can be searched. It's not, it doesn't expand the scope of the search condition, and therefore it's not a material difference.
And she also added papers, which was not in the oral sentence. Yeah, go ahead.
Sorry, thank you. Papers would also, it would be the same thing. So the places that the court said could be searched, vehicle, residence, electronic devices, within those places, papers and effects can be searched. That's clarified in the written judgment. But it doesn't expand the places that can be searched.
How does that not conflict with our ruling in Rogers, which requires the oral pronunciation to be explicit and accurate?
So Rogers also said that it doesn't have to be a perfect match between what is orally pronounced and what is in the written judgment. It just can't be a material difference. So really what we're looking at, I think, is—
How is this not material?
It's not material because it doesn't expand what can be searched. The effects or the papers that could be searched are just going to be within those locations that the court has already explained orally at sentencing that the defendant must submit to search under his conditions.
Is that material difference, in what case have we said that in?
Your Honor, United States versus Mathis, which I believe is the subject of one of our 28J letters, talks about materiality. It's also—
But that material difference is your statement, then?
It is, Your Honor.
All right, okay, that's your, okay.
But this court has never required the district judge to read word for word what the condition is and then have that word for word match what is in the written judgment.
We have used words like expressly or explicitly and things like that, too. Didn't we do that in Rogers, one, or some other case, or so many of these things? What do you say about this Eichwanger thing?
Are you asking about the constitutional avoidance?
Well, I'm asking about Eichwanger. How come nobody knows anything about Eichwanger? The constitutional avoidance doctrine is that we don't reach constitutional questions unless we have to. And he says we don't have to. proponent does, your colleague does. We don't have to because we can decide it on a non-constitutional basis, and that's his second issue. So we don't have to deal with this double jeopardy problem.
Your Honor.
Double jeopardy is constitutional.
Yes, Your Honor. The government's position is you do have to deal with the double jeopardy question here
You're
first.
saying we do have to deal with it.
Yes, because if the
But then
defendant.
we have to deal with the non-constitutional question first.
No, Your Honor. The double
We
jeopardy.
don't deal with constitutional questions unless we have to.
But in this case, Your Honor, if the defendant sentence violated double jeopardy, there is no resentencing. He's effectively already served his entire sentence. So if the court were to decide this just on
You're
Rogers,
saying we can't avoid the constitutional question.
not here, Your Honor. Because if the court decided to remand this on a Rogers Singletary issue, the question would still remain whether reimposing a sentence of 450 months or any sentence at all at this point would violate double jeopardy. And so the government's position is that question needs to be addressed first for the district court to be able to address anything else.
That's turning Eichwander upside down.
I don't believe it is, Your Honor.
That's what your colleague said.
The government disagrees. I think in this case, because the double jeopardy question goes to the question of whether the defendant should be in prison at all anymore, it needs to be decided before there's a decision about whether there should even be a resentencing. But our position, again, is that there doesn't need to be a resentencing at all in this case because the court did impose the standard conditions. It referenced them, ordered the defendant to comply with them. And that was clear from the record, clear enough that he is subject to them.
But the language, there was some language used in there that contemplated something happening later. It said, you will agree, you will agree, you will agree. Is that sufficient to do it that way? I don't know whether they're even raising that or not. That kind of jumped off the page at me.
It is, Your Honor.
As if later on when they wanted to search his house, that he was agreeing that he would agree or something.
Your Honor, I don't believe that precise issue is raised. I
And
think
all this contemplates that he would be released on supervised release, these conditions.
that's correct, Your Honor. And because the defendant has begun.
If he's doing 450 months, whatever age he is, that's some way in the future.
It's not that far in the future, Your Honor. I believe the defendant has.
What about harmless error? Y'all won't even argue that. I'll look that up for you.
Well, we argued
What
that.
about Rule 52?
Your Honor, I think the opposing counsel is correct that if there is a Rogers error, it is a de novo review in the court.
You're saying it's structural error then?
Yes.
The government concedes that Rogers error is structural error. Now, you'll be making some new law, I think.
For purposes of this argument, Your Honor, I think this court has said that if it's a Rogers error, it needs to be remanded. We do not believe there was a Rogers error here on either of the two issues raised by the defense.
But Rule 52 says any error has to be prejudicial to be recognized. Who repealed that? I may be misquoting the thing too, but that in effect is what it says, I think. I mean, you all got rule books in front of you. I suspect you know what it says.
And Your Honor, I don't believe that any error was prejudicial here, but again, I'm not sure.
It has to be prejudicial. That's what we call the harmless error doctrine. And then there's a plain error doctrine is another step.
Right.
If we review it de novo, we review it for harmless error. And we review it, that's what Roger said, or Judge Motza said in a later case maybe about Rogers, it's a review de novo because they don't have an opportunity to object because the order is entered, the judgment, the criminal judgment's usually not entered until the next day maybe, or later in the day. It's not entered at the time of the hearing. It's written up later. And
Correct.
So the opportunity to object is not there. So you have to review it de novo. You know, there's no plain error review. But the de novo review triggers Rule 52.
You mentioned Mathis, and which is a decision from, I guess, earlier this year from this court, and also the Beverly case from 2023, where it says, this court has said that it has to, the oral and the written conditions have to be a match. If not, it's reversible error.
That's correct, Your Honor, but they don't have to be a precise word-for-word match. This court has never said that the conditions need to be a precise word-for-word match. They just can't be different in a material way. So there are cases, for example, where the court has imposed a search, you have to subject yourself to search based on reasonable suspicion, and then the oral judgment has said, or sorry, the written judgment has then said, actually, it's suspicionless. You have to subject yourself to warrantless search at any time with or without reasonable suspicion. Now obviously that's a problematic difference. That's a substantial difference in what the expectations of the defendant are at the time he leaves the courtroom. Here, what was pronounced orally and what was in the written judgment are not different. The defendant is still subject to search at the places that were named by the court in the sentencing and then in the written judgment as well.
Judge Berner has a question.
Ms. Englander, one of the things you say is that the district court orally pronounced that the defendant shall comply with the standard conditions of supervised release. And I guess what you're trying to say is that the standard conditions made clear to the defendant that the conditions would include search of his effects. Is that what you're trying to say there? Because to me, I think the language standard conditions is vague, and it's not clear what standard conditions were referred to there. And so it doesn't solve your Rogers problem.
So those are two separate issues. The standard conditions of release are adopted by the district, and they were imposed by the court by referencing them and ordering them. The search condition is a special condition. So it was written up in the PSR, so the defendant had notice of it that way. The court imposed it orally at sentencing, separate from imposing the standard conditions, and then it was included in the written judgment. So
was it enough for the court to say at the oral pronouncement standard conditions of supervised release? Because that's not what those standard conditions are called, right? They're not called standard conditions of supervised release. They're called standard conditions. No, I guess the court said standard conditions in the district, and what they're called something else, right? So the court got the name wrong.
Your Honor, I see that I'm out of time. May I
You
respond?
answer questions as long as you receive questions.
Thank you, Your Honor. So there are standard conditions in the district. They are referenced in a standing order that has a specific number to it. But there's only one set of standard conditions. They also happen to be the same standard conditions that are in the guidelines. So when the court references those standard conditions, there's only one set of standard conditions that are being referenced there.
So you're saying it's enough for the court to simply say standard conditions and doesn't have to reference the number that you mentioned or even to say that they're standard conditions of supervised release?
That's right, Your Honor. In this case, the court did say standard conditions. We have standard conditions in this district. She went on to sort of explain some of what those are. She provided a few examples. She even used words like, things like this. And then at the end, she said, standard conditions you'll comply with. That was enough to incorporate those standard conditions that are referenced. And if there are no further questions, Your Honors, I'll take my seat. Thank you.
Anything else, Judge Berner?
No, thank you.
Thank you very much, Ms. Englander.
Thank you.
Mr. Brignac?
Dry throat. Thank you, Your Honors. Judge Berner, I wanted to say I did look at the standing order that is at issue. Obviously, we in the government dispute whether it was incorporated. It does not have a search condition, so even if this court were to believe that Judge Flanagan did incorporate them, it wouldn't have changed the search condition. And we've talked a lot about the word effects. I think maybe we need to, again, read that in context. Another word that's very different is any.
That search condition then would not be called a standard condition. It would be called a discretionary condition.
A special.
A special condition.
The search condition is a
different
special.
names for the others.
Different. There's mandatory. There's variations on standard, and that gets to Judge Berner's point of it
Is a
being
mandatory a standard?
mandatory, standard, special. So helps keep us employed with all of the complexity. But I would say, here's the difference. Here's why it
The
is
search condition, you say, is what kind of a condition?
special.
Special condition.
And here's why. He was sentenced to search your car, your house, your vehicle. Okay, I agree with the government. That would mean anything in the house, car, vehicle. But Joint Appendix 289, search the defendant's person, any property, house, residence. So here's an example's worth 1,000 words. He could have an effect, a suitcase, papers, whatever, have it at a friend's house, and under the written condition, that could be searched. That is an effect in any house. What he was sentenced to was
And that would make
your
entirely good
house.
sense in the context of the crime he committed, because he boxed up a bomb and mailed it to his wife and blew her up.
If Judge Flanagan had
Don't you have to use your common sense looking at these things too?
If Judge Flanagan had imposed that condition, the one that's in the written judgment, and we objected and she overruled us, I think this court would have no problem affirming her. The error is that she never imposed that condition, but it's in his written judgment. Look, this court is somewhat tired of Roger Singletary. The government is somewhat tired of Roger Singletary. I'm somewhat tired of Roger Singletary, but it's not our fault. The district judges keep putting conditions, at least in the Eastern District of North Carolina, keep putting written conditions down that aren't part of the sentence. And there's nothing to do other than just, Rogers and Singletary are clear on their face. This is a much more expansive condition. I'm also certainly not waiving our first Roger Singletary argument that comes down to, I think when she says, she never uses the word incorporate, she never uses the word, standing order. She says there are standard conditions in this district. She enumerates 4 of them with explanation, which would imply those are the only ones she's imposing. The written judgment imposes some other ones. I would agree, Judge Berner, I agree with my colleague that if you were to reach and agree with us on the first argument, he would be sent back for resentencing, although the answer at the resentencing is that you've already served the maximum possible on all of your counts. So a bit of form over function there, but I do think technically that's how it would work. I also, Your Honor, agree with you about constitutional avoidance, in as much as if this does go back for a resentencing, we're not sure what Judge Flanagan's going to do, and so, the double jeopardy issue may end up somehow going away, depending, and she may go with that. You were curious when he was getting out. According to the Bureau of Prisons website, he's getting out September 2027 if this court does nothing, but obviously we think this was an erroneous sentencing, and he needs to be resentenced.
December of 2027, it's based on the 450 months?
Yes, Your Honor. So based on the time he served, based on
What he's got now?
based on the Bureau of Prisons assumes, and I think in Mr. Bullis's case it'll be true, assumes he will have his good time earned credit. And that number on their website tends to be pretty accurate. So last I checked, it was September 30th, 2027. But obviously we're here saying that.
Can we take judicial notice of that kind of thing?
I think Your Honor can. It's the Bureau of Prisons website. It is bop.gov.
I'll take your word for it. I haven't ever looked at it.
Yeah, no, it's, my clients are often concerned about when they're getting out, so that is
I
a
know,
website I go to.
And what we're talking about here, these conditions of release, wouldn't apply unless he gets out.
Yes,
So it's all speculative in that context too.
yes.
Maybe that would be taken into account in this harmless error review.
And may I,
What if he had a
may I
condition or something?
may I respond, Your Honor?
Sure.
Okay, thank you. My time is up. Part of the reason this court has resentencing as a Roger Singletary remedy, which I know certain judges up here believe it's not a remedy we should have, is because, if you read Singletary, it makes sense. The incorporation, the fact that the supervised release conditions and the time you're serving, it's all part of this unified sentence, which I know sort of undercuts my first argument, but here we are, and so this really does need to go back, because if he does end up with different conditions, she may end up wanting to impose a different amount of time.
And that's the argument for the plenary resentencing aspect of this Rogers error.
Yes, Your Honor. Exactly, which I know,
So
again,
you potentially could end up getting your client more time
yes.
if it's a plenary resentencing.
Yes.
If you get a relief, I mean.
That could very well happen, obviously, but this court would reject, if this court rejects our double jeopardy argument,
Yeah.
then yes, a plenary resentencing is a plenary resentencing. I mean, there's some vindictive sentencing arguments out there, but realistically, yes, if he is being incredibly bad, obvious example, if he is being bad in the Bureau of Prisons and he goes back for resentencing, the government has every right to bring that up, and he could get more than 450. That said, he deserves a resentencing, and that's what we're here asking for.
Thank you very much.
Thank you.
Judge Berger, did you have anything else?
Oh, thank you.
No, thank you.
We appreciate counsel's arguments, and the case will be taken under advisement, and
Motion for a preliminary injunction against the Department of Labor's rules setting the minimum wages for H-2A agricultural guest workers. The final rule is unlawful for two independent reasons. The first reason it's unlawful is because it failed the Supreme Court's State Farm test.
is that an issue that you're raising here that's unlawful?
Yes, it
I
is.
thought you were feeling the denial of an injunction.
Yes.
Well, it has to be, it's a likelihood issue on the legal issue, isn't it?
Most definitely, yes, Your Honor.
Well, it's a likelihood of success on the merits. The
Which
judge denied the injunction because it said it didn't satisfy the standards, and that's what you're appealing, is the denial of a preliminary injunction.
that is correct, Your
Judge
Honor.
Ridinger, and he wrote an opinion on it
Yes, Your Honor.
a year or so ago.
Yes. We do not have the
The
burden.
case has changed, y'all still litigating.
Yes. The case
And
is,
you've got a motion to amend your complaint pending.
no. We finalized the motion for, the briefing on the motion for summary judgment, and we're waiting for action on that.
I thought that the motion that you're on the third amended complaint,
Yes,
or second amended complaint.
yes. I believe what we
The
did,
third complaint, the Second Amendment complaint.
what we have been.
Has that been filed? Or is it pending?
It's pending. I believe it's been
pending.
filed. I believe it's been
Well,
filed.
I've got a copy of it.
Well, then,
But it says on it, it calls it, but anyway.
well, I stand corrected, Your
There's
Honor.
stuff going on in the district court
Yes.
that's not in this record,
Right.
because you're appealing a denial of a preliminary injunction, and you've changed the complaint.
We
So
have,
the injunction ruling doesn't even deal with what you're proposing to the court now.
no,
To the district court, same district court, same judge.
that is incorrect, Your Honor. Okay.
So how is this thing even viable?
What we did is we added plaintiffs. And what we did is we focused with respect to the issues, the particular issues that we're presenting to this court, whether the government considered all relevant aspects, all important aspects of the problem before it, has been litigated several times, in every single pleading that we filed before the district court. The second issue, whether the government properly considered financial cost, has been considered in every pleading before the district court. It's been ruled on, both issues have been ruled on. We have raised the same issues repeatedly in order to ensure that everything.
These things that were raised after the denial of the preliminary injunction or before the denial of the preliminary injunction?
Before. Every single one was before.
Okay, but what about all those things that were raised after the denial of preliminary injunction?
Well, what we did after the denial of the preliminary injunction was the government argued, again, waiver. You waived this, you didn't bring this, and so what we did is we clarified the complaint to make it very clear and make it unquestionably clear that, in fact,
So
those.
you amended the complaint?
Right.
You agree you amended the complaint?
Right.
And you had some different claims?
No. What we did is we clarified the claims to deal with the government's argument. What we did is we showed that throughout the pleadings, throughout every document that we filed, we established that we had made these arguments. We've been saying that the government had to consider the effects of illegal immigration in every single pleading that we filed in this case. And what we received was an argument that, well, no, you waived it because you didn't say it precisely, you didn't say it clearly enough. So what we did is we said it clearly enough. Government wants a new pleading saying it clearly enough, it's clear.
Now, you raised a cause of action that the final rule was not approved by the Attorney General after consultation with the Secretary of Labor and Secretary of Agriculture.
Right.
Isn't that a new cause of action?
That is. That issue,
That's a new
that
cause of
issue,
action.
that
So
issue.
you're litigating a different case than the pending here.
Well, these particular issues were brought and presented to this court, over which this court accepted the appeal and has jurisdiction. With respect to the fact that the Attorney General was required statutorily to approve this and did not, no, that was raised because the government said you waived that and you can't bring
That's
it
a
up.
new issue that you've raised
Right,
since judge writing the rule.
right. But it doesn't affect, we would argue, the fact
You
that.
have to be arguing that, that's right.
Right, exactly.
Otherwise you're moot.
Exactly.
So the question is, why aren't you moot?
We're not moot because these issues are live issues. They're raised. They've been raised in every single pleading. They're not moot because the particular
You're trying to
procedure.
litigate a different case.
Well, we are litigating the same, fundamentally a case is this. If we go back to the old, mine workers versus Gibbs, we have raised a new issue in the same case. These issues were presented to this court, and we briefed them, and this court has been proceeding with respect to those issues. It is live, it is moving. It's obviously we're here to discuss those issues. The later injection of this other issue does not change the fact that this court has exercised jurisdiction and has exercised its review authority as to whether or not the preliminary injunction was properly granted.
Well, you can appeal a denial of a preliminary injunction.
Right.
There's no question about that. We have jurisdiction for that. But what you're asking us to review is different than what you're litigating now. That's my point. And highlight that in the impact thing. You say it doesn't.
I would say it doesn't, because the issues are precise. The issues are the ones that Judge Reininger decided, made his decision on. It is not a question of sandbagging the district judge or bringing something to your honors that we didn't ask the district judge to rule on. He ruled on everything. Everything was presented to him, and he ruled. We argued it, both sides argued it very vigorously, and we presented it to this court. So, the issues, there are two issues here. Issue number one is whether or not the agency considered every important aspect of the problem before it. That is a fundamental requirement from the Supreme Court's State Farm decision, which almost all of modern administrative law goes back to.
So what was here, though, we reviewed for what we call abuse of discretion.
Right. Yes, and Your Honor's, this court's cases define abuse of discretion in two ways. With respect to factual issues, it's clear error. But with respect to legal issues and understanding and applying the law correctly, it's de novo. Sometimes the court describes it as misapprehending the law. Sometimes it describes it as pure error. Bottom line is the court uses the word, all the cases use the words abuse of discretion, but it's defined as a legal error. And it goes back to what Your Honor said. Because Your Honor pointed out that all we have to do is show likelihood of success on the merits. We don't have to.
That's not all you have to do.
Well, we have three other elements.
Four prongs.
Yes, Your Honor.
In the Winter case, four prongs.
Yes.
That's one of them.
Right. And that's been the fundamental one that we've all focused on. Because in Winter, the last two, the public interest and the equities merge, because it's obviously not in the public interest for there to be an agency of the United States government acting unlawfully. With respect to irreparable injury, there's been no appeal on that issue, because it was the judge decided that we lost on that only because we lost on the likelihood of success on the merits, and we briefly briefed that in our opening brief. So likelihood of success on the merits. It's been the focus of our efforts on it. Number one, the agency is required to review every single relevant aspect of the problem. That's what the Supreme Court says. One of those relevant aspects, when you're setting a minimum wage for agriculture, is whether or not it will have effects on illegal immigration. We commented on that. Other commenters commented on that. We provided data that it would have an effect. And then the Department of Labor, unlike what it's done.
Well, let me ask you, to Section 1188, the section that you're
Yes.
here on, does not mention, even though the title does, it does not mention illegal immigration. It talks about the depression of wages, domestic wages. I'm curious, so why should DOL have considered illegal immigration?
Well, the answer to that comes from the Department of Labor itself. In 2020, the Department of Labor issued another final rule that eventually actually ended up being this rule. And the Department of Labor's position then was straightforward. In setting the AWER, the department must balance the interests of workers and employers. Setting AWERs that are too high in any given area will harm U.S. workers indirectly by providing an incentive for employers to hire undocumented workers. So what happens is if you drive people out of the H-2A program, they don't go and hire domestic workers because there aren't enough domestic workers. And that's documented in the record on J189, our expert's report. What they do is they go find people who are unauthorized. And that has an effect. The current studies show that it has a depressive effect on U.S. workers' wages. So the Department of Labor needs to carefully balance these considerations. Because if you go too far in one direction, it's like robbing Peter to pay Paul. You really don't have any benefit. All you do is replace H-2A, legal H-2A workers who have protections, who have the Department of Labor to investigate with unauthorized workers. And Congress did not want that.
But you would agree that the section, only the concern, the purpose of that section deals with the depression of wages, domestic wages. It doesn't discuss illegal immigration at all.
It does not use the term specifically, but I respectfully disagree with the premise of the question, because everything in IRCA, all 7 titles, deals with reducing illegal immigration, in particular the employment of people who are unauthorized. Title I was control of unauthorized aliens. Title II was legalization. And why did Congress want to legalize the workers? Partly humanitarian reasons, but partly because they could participate in the workforce on an equal basis, lifting everybody's wages. Title III is the one we're dealing with, Section 1188. You're right, it doesn't use those terms, but by creating an expanded H-2A program, it allowed agriculture to hire people legally, eliminating the jobs magnet, which is the term they all use. So if there aren't jobs to be had, then people won't come, was the idea. And then Title IV's reports, Title V and 6, 7 deal with other issues. But they all relate to controlling and reducing illegal immigration. And it is
Mr. Hall,
Yes,
Mr.
Your
Hall,
Honor.
can we, in your time, turn to the accuracy of the cost estimate issue?
Yeah, the cost estimate.
So I want you to address the facts that are put forward in the Farm Worker Justice amicus brief that says, as of about a year ago, July 26, 2023, 96.7% of H-2A workers with AEWRs calculated under the final rule were assigned based on the field and livestock workers category. So that's only about 1% lower than what the DOL estimated, and you say that the DOL estimate was arbitrary. So what's changed in the last year that we should be relying on to find that the DOL estimate was arbitrary?
What we should be relying on is the Department of Labor's own expertise. In footnote 95 of the preamble, the Department of Labor says if you want to figure out the cost, and if you want to figure out how many applications are going to change, you need to look at individual applications. Says that. That's the Department's own expertise. Then we get to the data set, the Department says we're not going to look at it. With respect to the experience under the new rule, it's varied. Okay, for instance, my client, USA Farm Labor, and our representative's office of the court has found almost 5% of its classifications have changed. That is finding that employers are altering are changing how they're doing business more inefficiently. Some of their clients are losing money directly. My client has lost about $860,000 trying to, again, all as an officer of the court, trying to comply with this new rule. So Farm Worker Justice has its estimate, we have our estimate, but really the only estimate that counts is the one that the Department of Labor should have made using the methodology that it said was the correct methodology. And that's footnote 95 of the preamble. And my time is up unless there...
Anything else, Judge Byrne?
No, thank you.
Thank you very much, sir. Ms. McTigg,
Good morning.
good to have you with us.
Thank you. May it please the court, my name is Alexandra McTagg, and I represent the government in this matter. I want to start briefly answering the questions about the procedural posture of the case. So there are different issues briefed on summary judgment, which is fully briefed below. After summary judgment was fully briefed, the plaintiffs made a motion to amend their complaint. That motion is pending. The government opposed it. So at this point, the operative complaint is still the complaint that was at issue for the preliminary injunction, but the summary judgment briefing addresses different issues, and they have moved to amend the complaint. So depending on what happens there, it could moot out this particular appeal.
In the district court, you filed a motion, I believe, to dismiss for lack of standing. Do you still contend that these plaintiffs lack standing?
We don't at this point, Your Honor. Now, I would actually like to start with the last two winter factors, which were not discussed at all. And the reason for that is that the plaintiffs have to establish all four winter factors separately. These last two factors, the balance of harms and the public interest, merge in a case against the government. But the district court found that the plaintiffs did not satisfy those factors, and that alone is a basis to affirm the district court's decision. And it made three findings with respect to these prongs. The first one related to the harm. So the district court found that the plaintiffs could be harmed by this final rule because they would be required to make payments under the rule that they wouldn't be able to recover. But the court found that there was equal harm to the workers if an injunction were entered, because then they could miss out on payments that they would be entitled to under the final rule. And so the harm was two sides of the same coin. It didn't weigh in favor of the plaintiffs. And the plaintiffs don't seem to challenge that finding as clearly erroneous on appeal. What they say is, well, the farm workers may not be entitled to the payments, but that's a different question. That's a merits question. And the issue here is, did the district court make an error in deciding that the harm did not weigh in favor of the plaintiffs because it affected both sides equally? And our answer is no. The district court was correct. He did not err in making that decision. The second issue on the last two factors was that an injunction could inject uncertainty into the H-2A program because the farmers wouldn't know exactly what workers should be paid under their contracts if an injunction were entered. And plaintiffs also don't seem to dispute that there would be uncertainty from an injunction. And so the question is, they say this court could provide certainty, but again, the question is, was the district court clearly erroneous in finding that there could be uncertainty injected by an injunction instead of letting this case proceed in the district court? And there's nothing clearly erroneous about that finding. And in terms of the public interest in enforcing a duly enacted statute, district court said there is a public interest in enforcing a statute, and that is what the final rule does. It enforces Section 1188. And the district court found that in this particular context, when we're talking about immigration, it's something that implicates the government's sovereign interests. And so typically those statutes, there's a higher interest in enforcing statutes that implicate the government's sovereign interests. Now, the plaintiffs come back and say there is no interest in enforcing a rule that violates the APA, but at best that gets them to a wash, that the factor doesn't weigh one way or the other. And so it was not clearly erroneous for the district court there to find that there's an interest in enforcing this particular statute. So the last two winter factors simply don't weigh in favor of the plaintiffs. That is what the district court found. That was not clearly erroneous, and this court can affirm on that basis alone. Unless there are any questions there, I will move on to the likelihood of success. So I'll start with illegal immigration. The plaintiffs are arguing that the final rule is arbitrary and capricious because DOL didn't consider how to control illegal immigration in setting its AWR, the AEWR, AWR. So as an initial matter, we do not believe that that argument was really presented to the district court. We believe it was forfeited. And the reason for that is that when we were talking about the issues before the district court, it was a question of DOL's economic analysis. When DOL made the economic prediction that their rule in setting an AWR for this subset of farm workers would avoid adverse effects to the wages of U.S. workers similarly employed, that was their prediction. And the plaintiffs came back and said, well, it could increase the number of undocumented workers who are hired, and that would in turn decrease the wages of similarly employed U.S. workers. It would have an adverse effect. So it was couched in terms of what is the economic prediction that is going on here. And there was nothing arbitrary and capricious about how DOL made its economic predictions. Plaintiffs didn't argue, as they do on appeal, that as a statutory purpose, DOL was required to consider effects on controlling illegal immigration when setting its AWR. And as this court noted, the statutory text of Section 1188 does not mention illegal immigration. It sets forth two things DOL is supposed to consider.
Well, let me ask you something, because on your exhaustion issue, the district court addressed the issue that's before us on JA 413 regarding the effect on illegal immigration and food supply.
So yes, but I would say that the district court addressed it in terms of the economic analysis, that it was not arbitrary and capricious for the Department of Labor to say that its AWAR rule was going to prevent adverse effects, despite an argument made by the plaintiffs that the economic results of a higher AWAR would be depressed wages. It was not this broad-brushed argument that any statutory purpose has to be considered in rulemaking. And it's a nuance that has changed. I agree, it's not like as clear as day, but it is an important nuance that we're talking about, because we were talking about the purposes of 1188 and the program, and this case law that talks about how the Department of Labor needs to balance the competing goals of an adequate labor supply and protecting the jobs of U.S. workers, and they do that primarily through this AWAR to prevent adverse effects on the wages of U.S. workers. And so 1188 talks about two things. They have to certify that there aren't sufficient workers available, and that the hiring of the H-2A worker will not cause adverse effects to the wages or working conditions of U.S. workers similarly employed. It doesn't talk about illegal immigration, and I think here it's important to note that this adverse effects language was not new to the IRCA of 1986. It was in the original INA in 1952. And so if you look at plaintiff's argument, their argument is the statutory text about adverse effects meant one thing in 1952, and that same carryover language in the amendments of 1986 now means something different because of a statutory purpose. But in all of the case law that talks about DOL's authority to set the AWAR under Section 1188, I'm not aware of a single case that says that DOL had to consider illegal immigration. And in fact, if you look at the structure of the statute, we're talking about three main titles, and three purposes. Title I was about controlling illegal immigration, and it talked about doing that through employer sanctions and a verification system. It talked about the legacy INS and the immigration courts, and that they were responsible for the enforcement activities. Title II was a pathway to legalization, so that's a separate purpose, legalization of undocumented individuals already in the United States in 1986. And then Title III was about the temporary worker program. So prior to 1986, there was one program called the H-2 program, and in 1986, they divided it into H-2A for agriculture, H-2B for other temporary workers. There's nothing in Title...
Turn you to the cost estimate issue.
Absolutely.
That issue causes, I think, there are a number of questions on that issue, and specifically, I'd like you to address the question of what degree of deference we owe the agency's cost prediction post-Loper-Bright, and also, I guess put another way, how much incompleteness or inaccuracy in a cost estimate is really acceptable at this point?
So I don't think that Loper-Bright is going to change the arbitrary and capricious analysis under State Farm. Loper-Bright talks about how to best read a statute, and it overruled Chevron. So the agencies are no longer getting Chevron deference if there's ambiguity in the statute. It also talks about the idea that sometimes the best reading of the statute is one that delegates authority to the agency, that Congress makes those types of statutes all the time. And that, in a lot of ways, is what we're talking about with Section 1188 and DOL's setting of the AWAR. They need to certify that there will not be adverse effects on the wages and working conditions of U.S. workers similarly employed, and the way in which they do that is what's been delegated under the statute. When it comes to the the actual cost estimate, so what we're talking about here is that it falls within the agency's expertise, and under the State Farm analysis, and the arbitrary and capricious analysis, the agency has to consider the relevant factors, but they are giving some level of deference for their expertise. And in this particular case, the district court credited the Department of Labor's explanation in the final rule that any reclassifications would be de minimis. And so what plaintiffs are really talking about here when they're talking about the cost of the final rule is that the majority of farm workers are going to fall under the prior rule and the Farm Labor Survey data. And you have this other section of farm workers who may be reclassified. Well, let me take that back. You have those who are farm workers. You have those who are clearly within the OEWS wages because, for example, they're heavy truck drivers or they're construction workers. And then you have this edge case of people who in the labor certification are described in a way that they may have duties that fall within the Farm Labor Survey codes, and they may have duties that cannot be put into the Farm Labor Survey codes. They fall into OEWS. And so in that case, they would be paid the higher wage. So if
Is this the overlapping duties issue?
It is. And that is the part of the cost estimate that plaintiffs take an issue with, because they say that even though DOL found that the overlapping duties would be de minimis, based on its experience in how this rule was, in labor certifications and how the rule would work, they're saying DOL still had to make that cost estimate, that it wouldn't be de minimis. They disagree. They say it's not de minimis. And so what the district court found was DOL explained why it would be de minimis based on the broadness of the categories and the fact that farmers may just change how they. So it's a question of which data. There were over 25,000 labor certifications that were submitted in the prior two fiscal years. And so when it comes to the particular SOC code that was assigned to the job opportunity in the labor certification, that gets entered into a database. And those final SOC codes were reviewed because all of that information is readily extractable from the database to determine what the codes were. When it comes to whether some of the prior certifications would have been reclassified under the new rule, that analysis was not done because that would require going back to the written description of what the job opportunity was going to entail and then making a new analysis as to what SOC code would apply. And so it would require reanalyzing the underlying petitions as opposed to pulling the data directly from the database. And so,
was your client under the obligation to do that and failed to do so?
No, because the cost we're talking about, DOL determined, would be a de minimis cost because the Farm Labor Survey categories are very broad. And so many of these, most H-2A workers are still going to fall under those categories under the Farm Labor Survey, and their wages aren't going to change under the rule. And so there's no requirement that a agency has to come up with a perfect cost estimate or that it has to estimate every single minor issue that might come up under a cost estimate. The cost estimate that DOL did here was sufficient under the rule. It was reasonable, it was reasonably explained, and we do not believe it was arbitrary and capricious. So just to summarize, the government's position is that this court can affirm on the fact that the last two winter factors were not satisfied. But if this court is going to consider the merits arguments, the government does believe these were forfeited, that they really weren't presented to the district court. He didn't really have an opportunity to consider them. But even if the court is going to get to the ultimate merits on these issues, nothing that the Department of Labor did was arbitrary and capricious because there's nothing in the text of 1188 that requires it to consider controlling illegal immigration, and the cost analysis was sufficient. Thank you.
Thank you very much, Ms. McTeague. Mr. Hall?
Thank you, Your Honor. I'd like to start with the obligation to consider financial cost and to do so in a manner that's reasonable and that is consistent with the Department's own the Department of Labor's own expertise. Because what we have here is, in footnote 95, the Department of Labor tells us, this is not Wendell Hall saying, it's not plaintiffs, it's not even government counsel, it's the Department of Labor's own experts saying, the only way that we're going to know what the cost of this rule is going to be is if we look at individual applications. And then that's what they say. It's not me. Number two, then the Department of Labor sees, this is the data. Here's the 25,150 application set of data. It's all electronic, can be searched easily if they wanted to do it. And then the department says, well, we're going to speculate because it's going to be, maybe it's going to be this many will be reclassified, maybe it'll be 2.91%, maybe it'll be 4%, maybe it'll be 30%, maybe it'll be 11%. We don't know, we're going to speculate. The Department of Labor, Ms. McTagg says several times, oh, this is de minimis. Well, that kind of excuse didn't work for this court in Azar. HHS there says, oh, the physical separation is going to be de minimis. It's only going to be $30,000. But this court insisted on an explanation for that was grounded in fact, that was grounded in studies, that was grounded in something more than the department say so. And that's what we have here. But the thing about it is the department's own say so is you needed to look at individual applications. This is, I was sitting there listening to Ms. McTagg describe briefs and arguments that I wrote, which I never did. We have never challenged directly a prediction of the Department of Labor. What we've said is that the Department of Labor hasn't used reasoned decision makings to come up with a prediction. The Department of Labor itself in footnote 95 tells us what it has to do. And yes, under State Farm, it has an obligation to review the relevant data. What it did here is it tiptoed up to the relevant data, looked and said, no, thank you, we're not looking at it. That violates, it's not reasoned decision-making, that's not reasonably explained. We're just not going to do it because we think it will be really small. That didn't work in Azar, and I don't see any reason, I didn't hear any reason why it ought to work here. Let me hit the winner factors. We specifically argued those. We specifically argued them in our brief, and fundamentally,
And you argued them for Judge Whiting.
yes, exactly. I don't know why.
And that's right, and Judge Whiting
Yeah, we lost.
ruled against you.
Exactly.
And he wrote an opinion, ruled against you.
And he
explained
ruled-
why he was ruling against you.
And he ruled against us because he
He's a very
didn't think we were going to
careful
provide. I'm sorry, Your Honor.
I'd say he's a pretty careful fellow.
Well, even the best stumble sometimes. And fundamentally what we have here is if it is illegal, there is no right to an elevated wage, so the workers are losing nothing they're entitled to. Obviously, it's wrong for the agency of the U.S. government to implement a rule that costs a lot of people a lot of money. Their estimate was $37.5 million a year, $375 million over 10 years. That's a lot of money. But yet, what we get, is de minimis. No. So let me focus, before I move away from costs, let me just summarize it. Number one, the department told us what method it needed to use to come to a rational estimate of cost. It told us what data it needed to look at to come to a rational estimate of cost, and it didn't. The department, and it's important to note, in this court's Sierra Club case, this court was well-nigh skeptical when it said that agencies can't run from accurate data. They can't complain, they can't get data. If they need data to make a rational decision, their job is to go get it. And if they're going to say, we don't have data, they need to show that it's impractical. And in Sierra Club, this court said, impractical means well-nigh impossible. Here, why not do a sample? This is the Department of Labor with the best statisticians in the country. Why not just pick 150 and come to a rational inference? They didn't do that. They didn't do the very thing that their own experts said they needed to do. And so what we have is we don't know what the cost is. All we have is, trust me, I'm the government. But the fact that we have an APA says we don't trust them because of the government. We review their reasoning and we ask that they look at the right things with the right methodologies. So fundamentally, no, this is not an issue of predictions or anything like that. Did you follow the recipe? Did you do what you needed to do?
You're just, I know that you're running out of time.
I know.
I want you to respond to, she's saying that you did not, the last two winter factors, which of course you know, the I think it was the public interest and the harm. And she said there was harm to both sides. So it did not weigh in favor.
Right. First of all, the harm on both sides argument derives from this concept that the workers have a right to a particular level of adverse effect wage rate. And I'm not talking people who have already worked according to a contract. I mean, prospectively, there's a right. So therefore, if the adverse effect wage rate isn't raised, they've lost something. That's just not true. There's no right to an elevated wage rate. In fact, the purpose of the adverse effect wage rate is to protect the market, not to provide a certain level of minimum wage to H2 workers. So that, the essence, this concept that a worker has a right to a certain level of wage is simply inconsistent. And may I make one more point in response to the question? I don't want to,
Go ahead.
yeah, thank you, Your Honor. I am very gratified that the department is very concerned about the uncertainty of what happens if this is enjoined. It's very simple. We go back to the FLS. If amici are correct, and if the department's correct on their 2.91% estimate, that's not a lot of uncertainty. And that's not uncertain at all. I could look up every A word in 30 seconds in the Federal Register. So, thank you for your attention, and we ask that the district court's decision denying the preliminary injunction be reversed. Thank you.
Thank you, Mr. Hall. The matter will be taken under advisement. Judge Benjamin and I will come down and re-counsel, and we'll take a short break.
This honorable court will take a brief recess.
All right. In our third case today, number 23-1887, West Virginia Parents for Religious Freedom versus Christianson, et al., Mr. Weiss? Weiss, I mispronounced your name. You know, I mispronounce these names too often, and I apologize.
Thank you, Your Honor. Good morning, Your Honor. May it please the Court, my name is Chris Wiest. I represent the appellants and plaintiffs in this matter. The issue before the Court today is a very narrow issue in a case that presents, frankly, a number of issues, and that is this: whether a district court errs by entering a Pullman stay order in a case where only a federal constitutional claim is brought, challenging the application of an unambiguous state statute that all of the parties agree applies as it is written because of the existence of a separate state court remedy that the plaintiffs elected not to pursue, but which the district court held they must pursue and go to state court to pursue. And the answer to that question, Your Honor, is yes. The district court abuses its discretion because it is applying an erroneous view of the law by entering a Pullman order in that situation. Here, and we begin, Your Honor, with the premise that a district court has a strict duty to exercise jurisdiction conferred on them in the Martin case, Martin versus Stewart, unless an abstention doctrine applies. And here the district court entered a Pullman stay order, which requires a couple of things, none of the fundamental elements of which are met in this case. First, there has to be an unclear issue of state law that is presented for decision. And here the compulsory vaccination law, West Virginia Code 1634, is unambiguous. There's nothing unclear about it. And it wasn't.
And it's correct, you're challenging that statute.
In its application to these plaintiffs. That's correct, Your Honor.
Under the First Amendment.
Under the First Amendment, under the free exercise clause.
The free exercise clause of the First Amendment. How many clauses are there in the First Amendment, like 6 or 7?
I think that's right. Free speech, free exercise, free association.
You're only focusing on the free exercise clause.
That's correct.
Not any other.
That's correct.
And no other part of the Constitution.
That's correct.
And all you got, as far as you're concerned, is a constitutional claim.
A federal constitutional claim. That's the only claim.
One constitutional claim as to one statute.
That's correct, Your Honor. It's a one-count complaint in this case that was filed.
Well, and, I suspected that's probably what you needed there, if that's what you wanted to file.
Right.
But there's a different statute in West Virginia that the legislature came up with.
They did, Your Honor, the EPRA. What's interesting.
Bailey referred to that establishes a strict scrutiny requirement for a constitutional claim.
Well, no, Your Honor. It requires
What should it require?
a strict scrutiny standard under that statute. And so it's not a constitutional claim.
Statute on what statute?
Under the EPRA statute.
The one you were trying to challenge?
No, Your Honor. It's a separate statute. It's a separate remedy. Right.
But it does require strict scrutiny.
It requires strict scrutiny for claims brought under that statute. And there are no claims here brought under that statute.
Okay. But do you think that it doesn't purport to establish strict scrutiny for the federal courts?
No, Your Honor, not at all.
A First Amendment claim?
It does not at all.
They wouldn't have any authority to do that anyway, would they?
They would not. And I think, Your Honor, you're cutting to the quick of the issue here. West Virginia.
So what do you want us to do?
Your Honor, the same thing that the court did in Sonda, which was in the Sonda case, which was a case that came out this year. It was a decision in which Judge Bailey also improperly invoked Pullman. And in that case, as we are requesting here, we are requesting that you vacate Judge Bailey's Pullman stay order and that you remand for him to consider the rest of the issues. They've raised, for instance, and Judge Bailey never got to addressing it, an 11th Amendment and standing issues. By the way, Sonda says he's supposed to do that first before we even get to Pullman. He's got to go and effectively address that issue. If he finds standing in the 11th Amendment, ex parte
Mr.
Young.
Wiest?
Yes, Your Honor.
First of all, in Sonda, in that case, the judge didn't name which state law was unclear, but here, he did name which state law was unclear. And earlier today, we had a conversation about constitutional avoidance, and it seems to me the constitutional question here could be completely avoided if the law that you're challenging were found to be in violation of the EPRA. Do you agree that the mandatory vaccination law would likely fail under the EPRA standard?
Your Honor, I think it could be challenged under the EPRA standard. I think.
And what do you think would be the result of that case?
If a claim were brought under the EPRA statute, and here it has not been.
But if it was, hypothetically, let's
Right.
say if that case was brought, what would happen?
Presumably, it would be struck, or presumably it would be found to be inapplicable, or the EPRA would provide perhaps relief for these plaintiffs. I think the appellee would argue it does not.
I'm asking your view, what would happen in that case?
That the EPRA is another mechanism for relief. I think we would concede that, Your Honor. It's a mechanism for relief we've not asserted. It's under election remedies we do not intend to assert, but it
do you
is another
agree that
avenue.
if the EPRA were found to be violated by this mandate, then your case would be moot?
I don't think, well,
And by the EPRA, you're talking about what's called the Equal Protection for Religion Act in the West Virginia Code.
yes, Your Honor, 35-1A-1 of the West Virginia
So
Code.
if a state court, just
Signed on last
hypothetically,
year.
hypothetically, if a state court were to find that the mandate violates the EPRA, would your federal case then not be moot?
If the same plaintiffs brought a claim under the EPRA and got relief, then they would ostensibly, I think it could be moot in that instance. The problem with that, Your Honor, at least from the perspective, well, from a number of perspectives, is one, my clients have not asserted an EPRA claim, and they've disclaimed any intention to do so. And I think if you look, for instance, at this court's precedent in educational services versus
Why
Maryland State.
haven't your clients asserted an EPRA claim? It's an even higher standard than the federal constitutional standard. Why wouldn't they bring that claim?
Your Honor, for one, there's a forum issue. They could not bring that in federal court. That would have to be brought under Pennhurst in state court, for one. And for two, at least as they see it, if you look at the politics in West Virginia, there's been efforts by some legislators to enact a religious exemption that has failed. Their concern is if they win under the EPRA, the legislature is just going to go back and change the law so that it forecloses the very relief that they're seeking. They're looking for permanent relief.
And your plaintiffs don't want their children to be vaccinated before they go to school.
Your Honor, our plaintiffs have
Isn't that
sincerely, yeah, they have sincerely held religious beliefs.
Isn't that right? They don't want to be vaccinated against chickenpox, hepatitis, measles, mumps, diphtheria, polio, tetanus, whooping cough, that kind of thing. And they say they don't have to do that because they're protected by the free exercise clause of the First Amendment.
That's their claim, that
Which
the
is a
state is,
religious claim. And
Right.
There's no exception in the statute you're challenging.
right, there's no religious
That.
exemption
But there is one for what? There is an exception
for medical exemptions.
for medical exemption, and that's vested in the Commissioner of Health,
It is,
who you've sued.
correct. That's exactly right. And they, unlike 45 other
And
states,
the
there is
Commissioner of
no,
Health has apparently delegated his authority to somebody else, the state's immunization officer.
yeah, Your Honor,
You don't challenge that part of it.
not that delegation, there's a multi-step process in West Virginia for medical exemptions. It starts with the physician, then it goes to the immunization officer, then it goes to the state health officer. So there is this multi-step,
Then it goes to the circuit court.
under a deferential standard of review, that's correct.
But,
That is the process. And obviously, I'm not here to address the merits. I think that necessarily, just as their issues about.
you want us to
vacate.
reverse and remand.
To vacate and remand the Pullman stay order to tell Judge Bailey to address the merits, starting frankly with the standing 11th Amendment, which he has to under Sonda, and then.
Well,
and then
we wouldn't have to tell him what to do, we just have to vacate
That's correct.
What's the order you're challenging?
Right, although in Sonda, Your Honor, that is what this court did. It said, it vacated the Pullman order. It said you've got to address standing 11th Amendment first, and then,
We
yeah.
have to, why would we have to tell him all that?
Well, I don't think you have to.
I'm not supposed to be telling district judges to do things that I don't have to tell them to do.
I would think you wouldn't have to tell them to, Your Honor. Obviously, the court did so to Judge Bailey and Sonda, told him to address that first, but I don't think you necessarily have to. I think he, under the law, has to do that first.
The remand for appropriate
Further proceedings, correct.
That does the job, I think.
I would agree with you, Your Honor. And again,
It's not a very
Are you suggesting
complicated.
then that a requirement of Pullman is that the plaintiff had to have raised a state law claim?
Your Honor, I am suggesting that under Pullman, there's two requirements, neither of which are met here. The first requirement is there has to be an unclear issue of state law presented for decision. Obviously, raising the state law claim would present it for decision. If the EPRA plainly applied and there wasn't an exclusive remedy that had to be invoked under 35-1A-1B, which is the case, that could possibly do it. And then it has to moot or potentially moot the case. I think maybe we get to moot or potentially moot the case, but the problem here is...
You said it would moot your case, so you're saying that it's not presented. So what you're saying is that the plaintiff has to raise a state law issue in order for Pullman to be applied. But we actually have a precedent in our court, Franklin and Waldron, which is 493 F. 2nd 481, where the court ordered abstention even though the plaintiff never alleged a violation of state law, and actually, like you, insisted that the court not reach the state law issue. So
Your Honor,
how is that the case?
Yeah, this case is distinguishable for that reason. There was an ambiguous statute. Here, there is no doubt that the compulsory vaccination law is unambiguous. In fact, Judge Bailey's decision articulates in the first 4 or 5 pages of it what the requirements are. And they don't dispute, the appellees do not dispute it applies. The compulsory vaccination law applies. I don't even think the appellees would concede the fact.
We have a case on the issue.
And we have a case on the issue. We think
Sonda.
Sonda,
We've
yes.
got a case directly on point.
We think Sonda is on point. Yes, Your Honor.
Well, Workman, is that, Workman's on point.
Workman's not on point, Your Honor.
Well, Workman's on point. It's right on point.
Workman has been abrogated by the Tandon and
Well,
Folker
I didn't
cases.
say that, but Workman's on point. Judge Wynn, in 2011.
Your Honor, there were none of the issues that were raised in Workman that are raised in this case. Obviously.
That's a distinguish it. But
Right, well, and I think Fulton and Tandon has reflected a sea change in the U.S. Supreme Court's free exercise jurisprudence that's at issue.
Our sister circuits seem to disagree with you. Every one of the circuits that has reached, has looked at mandatory vaccination laws since Fulton and Tandon have agreed that first they applied rational basis and they upheld the laws. All 3 circuits, the First Circuit, the Second Circuit, and the Third Circuit.
Your Honor,
Is
the
that
Sixth
right?
Circuit has deviated from that in Dahl, obviously, so there is a circuit split developing on that issue, but I don't think
and the Second Circuit cited the Workman case.
in one of the cases, I think that's right. The Second Circuit's had a lot of jurisprudence on this issue that's kind of been all over the place, particularly in the COVID arena.
But that's not before us today.
Not before us today, Your Honor. And I think that argument will ultimately may be before you, but that's not the narrow issue that we're here on today. Your Honor, I see that I'm out of time. I'm happy to answer any further questions, or I can address it in rebuttal.
Judge Benjamin? Judge Berner?
No, thank you.
Thank you.
Mr. Ritchie? Mr. Ritchie, it's good to have you here, sir.
Thank you, sir. May it please the court, Zach Ritchie for the Appellees. I'd like to first address Judge Berner's questions to my friend. They have argued that the Pullman abstention was improper because they did not decide to plead a state law claim for violation of EPRA. I recognize that Pennhurst would not allow that, but nonetheless, the application of Pullman does not require that the plaintiff actually plead a state law claim, nor would it make any sense to impose this formalistic requirement. Pullman's a flexible, fact-dependent, equitable doctrine, and frankly, it would permit artful pleading by plaintiffs that could preclude application of Pullman. In any event, Pullman is about avoiding a needless federal constitutional decision and joining state law where there is reason to believe state courts could provide plaintiffs the remedy.
What about this Houston case that they cite that says it's inappropriate on facial challenges for Pullman extension is inappropriate on a facial challenge? In the First Amendment.
Certainly, Your Honor, I understand. I think what has driven the Supreme Court in First Amendment cases to eschew Pullman abstention is the chilling effect on rights that could occur, that's inherent in the delay that a Pullman abstention would create. We don't have that chilling effect here. What we have are, they're still able to exercise their religious rights, they're just not able to attend school, which might education rights under state law, not First Amendment rights. So I think that's distinguishable for that reason. Getting back to my point as to the cause of action, I think it's important that Pullman itself, if we look to the original case, is an example of why the plaintiffs, it's not a requirement that plaintiffs actually raise state law claim. There, the African-American railroad porters challenged the Texas Railroad Commission's regulation under the 14th Amendment. And the Supreme Court noted, though, that other parties had raised the prospect that the state commission lacked authority under another statute to issue that regulation in the first place. That wasn't presented under the 14th Amendment. And so the court said, let's let the state courts decide that earlier question that could possibly moot the federal question. And that's what we have here. We have another statute that, if applied, potentially is dispositive here. And that's what all that Pullman requires.
But one other question. So they have, the case before us is based on the statute, the CDL statute. And there's this argument that there's nothing ambiguous about that statute. And because there's nothing ambiguous about that statute, I think his argument is that puts us in a different position than these other cases that were cited earlier. What's ambiguous about this CVL?
So I will quibble with the standard here. I don't believe that Pullman requires a sort of a statutory ambiguity in the sense of a term of art here. What's required is an unsettled question of state law that, if resolved, can moot or present the federal case differently. And oftentimes, it is an ambiguity. In many cases, it is a statutory ambiguity that requires that.
I don't understand how this other state law is not challenged, has anything to do with this.
Right, Your Honor. I think it's simply a question of this open question. It's a new statute. It hasn't been construed by the Supreme Court of Appeals of West Virginia. For example, it would be a very different case had they done so in the context of this compulsory vaccination law, and we'd already have that answer. But it's not resolved. It hasn't been brought. There's very good reason to think it would apply here. It hasn't been briefed in this case, and it may be briefed if this court certifies questions. But nonetheless...
Are you arguing for certification?
We don't oppose certification, Your Honor. We think it serves...
You know that you're supposed to answer the question.
Your Honor...
Are you supporting certification?
We would be fine with certification, yes, Your Honor.
You're still not answering my question.
Yes, Your Honor. We will support certification.
You support certification to the Supreme Court of Appeals of West Virginia of what kind of an issue, for God's sakes? It's not any issue that relates to the litigation here on the basis of the complaint.
Right. The Pullman analysis is correct. It's not on the face of the complaint, but Pullman doesn't require that. All Pullman says is there an unsettled state law issue that could be resolved under state law in state courts that could potentially moot.
What about the Wisconsin case, the Supreme Court case that says that you said that this ambiguity is not the standard, but there they said there's no ambiguity in the state law, which would be the CBL, right? In the state statute, that the one that's being challenged, that the federal courts cannot abstain, but need to proceed and decide the federal issue. I mean, so that's why I'm asking you, what are you saying is ambiguous about the CBL?
we don't claim there is anything ambiguous about the CDL standing alone. What we are saying is it's an
I'm
sorry.
These acronyms,
The
these lawyers throw these acronyms around like they're working for the government or something.
The compulsory vaccination law at issue, West Virginia Code, Chapter 16-3-4.
Most time I understand them, but sometimes I understand them differently. There might be overlap and things like that.
I don't like acronyms either, Your Honor.
I didn't like and I've been in the Army, in the Air Force, and I didn't like them then.
To your point, Judge, I think in many cases, the Supreme Court has described the Pullman standard differently, has described it as there's an ambiguity in state law, there's an unresolved question, there's uncertainty about state law or a state law issue. It's broadly, it's an equitable doctrine that's sort of broadly written, so if the circumstances present, these are all factually dependent, factually intensive analyses. If there are circumstances, like in Pullman itself, where there was this other statute, this authorization for the Texas Railroad to empower them to issue regulations, the commission, if that could be read in a way, and there was a good reason to think it could be, that would knock out that order and not prevent the federal court from ever having to issue an advisory opinion on the 14th Amendment, then that is what, then that's what the Supreme Court directed. That's what Judge Bailey.
What would be an advisory opinion? An advisory opinion is rendering a decision that's unnecessary to resolve the case.
Certainly.
If it's necessary to resolve the case, it's not an advisory opinion.
Because of the enactment of the Equal Protection of Religion Act and the application on its face, the application to the circumstances of this case, the federal constitution question may well be needless if under state law the plaintiffs can get precisely the remedy they seek. And we contend, as we have before in the district court and here, that that is what the Equal Protection for Religion Act could permit, and that they should proceed to state court.
Counselor, in your brief you cite to an unpublished 2015 decision of the West Virginia Supreme Court, the Mercer County case, and in that, it's not clear to me why it's unpublished. It seems to be an important decision, but in that case, it's a strict scrutiny case, and a compulsory vaccination requirement is upheld under a strict scrutiny analysis. So why would the result be any different here if the Supreme Court of West Virginia were to reach the issue under the EPRA? Is it the exact same analysis?
That, I believe, is uncertain, Judge. I would not presume to say that it's the same analysis. The statute, which of course has come later, EPRA has come after that decision. The wording of that statute is somewhat slightly different than the equal protection analysis that is typically done as a constitutional analysis. And so I think we should...
Are you saying that the statute calls for a form of heightened strict scrutiny?
I don't, it hasn't been briefed, but what I'm saying is it uses different words, and I think the state Supreme Court could interpret the EPRA language perhaps to be different, and maybe heightened, maybe not, but we don't know, and it's an open question because of that, the different language used in subsection A1 of EPRA, and how they...
Can you answer the question that I asked your colleague about mootness? If the state court were to find that EPRA invalidates the vaccine mandate as applied to to the plaintiffs, would then this case be moot?
I think quite possibly, yes. I think it would depend on the precise disposition in the state court proceeding, how the relief, if it fully took care of the relief they were seeking in this court. So it would depend on what it says, but I think quite possibly, yes. And again, that is the purpose of Pullman, is to defer in certain circumstances where there is reason to believe that the state court under state law can resolve the challenge to state law, and so the federal courts do not have to render an unprecedented advisory opinion here on a federal constitutional issue. I think it's on all fours. We have the state attorney general on behalf of the state.
It would be an advisory opinion. You can strike the word advisory.
I do strike the word advisory. You're right, Your Honor. An unnecessary, we want to avoid an unnecessary federal constitutional decision, and there's good reason to think here in the circumstances because of EPRA that can be avoided. We have the state attorney general filing an amicus brief on behalf of the state. in the lower court. Again, even though EPRA was not raised.
Now, how is the Attorney General not up here standing where you are? I thought the Attorney General had an obligation to support the laws of legislation.
I am a special appointed Assistant Attorney General.
You're an Assistant Attorney General.
I am a specially appointed.
You are, so the Attorney General, because I thought that when I never was a state Attorney General or worked for him, but when I was with the federal government, the Attorney General defended our laws, and the federal laws.
And the office is indeed defending. I'm being supervised by 2 Deputy Attorneys General.
But so the Attorney General's got 2 positions here.
The Attorney General office is split. And
The Attorney General has 2 positions here. He has the position you espouse, and he has the position he espouses, which says the laws are constitutional.
Not quite. The Attorney General's position is what's for the state in the amicus brief. Our position is the position of Dr. Christianson and Commissioner
So the state has one
Davis.
position, and you have another position.
Yes, sir.
But you're the state Attorney General.
For purposes of defending the particular appellees, yes, sir. I'm a Special Assistant Attorney General. And so we have the Attorney General can speak for the state's legal interests, and he's done so below by saying that EPRA is directly relevant, applies strict scrutiny, and indeed, I think he goes as far as say it would be.
When they were fighting the Indian wars, they used to have in books that the Indians said that the people back in Washington spoke with forked tongues at both sides of their mouth. So that's sort of what West Virginia's doing here.
I would quibble with that, Judge. I think the Attorney General's within his state constitutional authority to render his views of the law separate from other individuals in state government, and that's what's happened here.
Have you abandoned your argument that this court lacks subject matter jurisdiction over Mr. Christensen?
Are you speaking as to standing, Your Honor?
Yes. Well, I believe you argued that the health commissioner doesn't have the power to enforce the mandatory vaccination law.
Yes, Your Honor, we haven't abandoned our, what I'll call the ex parte Young argument. We think that the connection is tenuous that is required under ex parte Young. As the court knows, the officials sued have to have some connection to the enforcement of law. We think here, Dr. Christensen does not, what plaintiffs seek, what the appellants are seeking is entry into school, public school, notwithstanding the vaccine requirement. Dr. Christensen cannot give them that relief. He does not enroll students, he does not permit them in.
But wouldn't he, so let me ask you, that takes us back to this Sonda case, this recent decision from this court. But wouldn't the, I think it's the same district court judge, but wouldn't the district court judge, and obviously I think Sonda came out after Judge Bailey ruled in this case, but wouldn't the district court have to go back and look and determine standing, especially since that's one of the issues that you all are arguing in this case is that, hey, we're the wrong defendant, you're suing the wrong defendant. Wouldn't he have to determine standing?
That is what happened in Sonda, is the court, there was a problem with the Pullman order itself, but the court also indicated in its remand that the court should, as a matter of confirming its subject matter jurisdiction, assess standing.
The court always has to assess jurisdiction.
Right. And we do raise the standing arguments, which are essentially derivative or the same as the ex parte Young arguments. This court's decision in South Carolina Disability Rights makes that clear, that the analysis of traceability and redressability are sort of intertwined with the same issues that are addressed in ex parte Young. So to the extent that this court finds that there is some connection there, then the standing issue, I think, doesn't carry much water. But we haven't waived it. We think it's still a live issue in the litigation, however.
What do you think about your colleague's argument that EPRA could be repealed? And so the court should reach the First Amendment issue even if EPRA would resolve, even if the EPRA challenge would resolve the case?
I think it's entirely speculation. The compulsory vaccinating statute could be repealed. And indeed, every session there are efforts to make substantial modifications to it. In this last session alone, there were substantial modifications to it that could have impacted the case. The governor ultimately vetoed it. But But nonetheless, that's speculation, and we just have to,
You say there were changes approved and vetoed?
the governor vetoed them, yes. Yes, sir.
The governor vetoed.
The governor vetoed it, yes, and it wasn't overridden. And so it's speculation, and I don't think we can rest on that in this case, because, again, the Pullman order at issue here was issued in August of last year. The plaintiffs could have at any point initiated a state court action under EPRA to try to seek the relief. They haven't done so. And we think
The plaintiffs are entitled to draw their own complaint. That's pretty well settled. The master of the complaint is the plaintiff. That's what it is. Now, if we certify something to the Supreme Court of Appeals of West Virginia, and they accept certifications, some states don't, including one in our jurisdiction, don't accept certifications at all, North Carolina. West Virginia does, but if they want to, they only accept it if they want to take it. Now, why in the world would they want to get mixed up in this? I don't see the incentive for the West Virginia Supreme Court of Appeals to be willing to address the issue that's presented in this complaint, which is the First Amendment issue.
Two responses, Your Honor. You're correct. They could refuse to answer, refuse to docket entirely within their discretion to do so. Secondly, however, it is my understanding and practice that they invariably take a certified question from federal courts. And certainly this court, they've done so on many occasions, especially lately.
So if we were to send a certified, what would be the question?
Well, at the end of our supplemental brief, we propose two questions that track the language of the statute and attempt to do so in a fair way.
Is one of them the statute that's not involved in this case?
Well, I would dispute that EPRA is not involved in the case. I think it's not been raised by plaintiffs in their complaint, but that doesn't control Pullman analysis.
I guess what I'm asking, because I don't think I think I understand your argument that the CBL compulsory vaccine law is standing alone. What they brought is before the district court is not ambiguous. But somehow, because now the state has this EPR, that it creates some ambiguity there? Is that the argument? Is that the argument?
We don't believe it creates an unsettled nature of an issue that presents a question of state law that, if resolved, could avoid the need for a federal constitutional decision. And again, Pullman is a great example of this, but a lot of Pullman cases do involve ambiguities in the traditional understanding of that word. But really what we're talking about are unresolved questions that, if decided under state law by states courts, could prevent the need for a federal constitutional adjudication.
And so what's the unresolved question? What's the unresolved question?
Yes. The unresolved question is whether the compulsory vaccination law that would survive the strict scrutiny type analysis presented by the legislature in the EPRA Act.
But in strict scrutiny, whether strict scrutiny applies in a federal courthouse is up to the federal courts. It's not up to the legislature of West Virginia.
Correct, Your Honor.
It couldn't be.
Correct. We don't argue that.
So then why in the world do you want to certify? So the West Virginia legislature can't tell us what our standard of review is. If it's strict scrutiny, we got to decide it, or the Supreme Court does or something, but we don't decide it. I mean, they don't decide it.
And all Pullman says is, if there's a potentially dispositive state law issue, we've got to give the state courts the first crack at it.
But they don't decide our standard of review.
Correct. I agree.
But wouldn't that be a parallel state law? And isn't that what I guess they're arguing, is that you would be creating a parallel state law question and that abstention doesn't apply? That Pullman would not apply?
Well, I think the question, the state law, unresolved state law question here exists whether they want it to or not. And whether they want to bring it or not is up to them. But what Pullman says is federal courts should stay their hand while plaintiffs can take these state law questions to state court and resolve them and potentially avoid the need for a federal court to issue that constitutional decision. And that's the genesis. That's from Pullman from the very beginning. And it doesn't create an exhaustion requirement at all. It's not a condition precedent to litigation. It's rather, these doctrines of abstention serve federalism by sending.
Did you ask Judge Bailey to certify this, or to enter the Pullman order?
To enter the Pullman order, yes, sir. We did request that.
So he reacted to you?
Yes, sir. There were cross motions for summary judgment, both on Pullman-related issues as well as the.
But you didn't ask him to certify it?
Correct. We did. That wasn't raised.
Certify.
I think you asked us for briefing.
No, we asked you to tell us something about it. I don't think, you take a position we ought to certify.
I think it serves the same ends.
They take a position we shouldn't. The plaintiffs take a position
Correct.
we shouldn't.
I think Judge Berner had a question earlier.
Yes. Go right ahead, Judge Berner.
You mentioned that you sought Pullman abstention in this case, and I wanted to know what level of deference we should show to Judge Bailey's decision to grant Pullman abstention.
Yes, Your Honor. This circuit, like all others, apply a abuse of discretion standard, and that analysis is if the standards, if each element of Pullman are met, then it's not an abuse of discretion. It's within the discretion of the court. And frankly, had this very judge decided, even though the elements of abstention were met, he could have decided in his discretion not to abstain. I think there's wide discretion granted to district judges in this respect. Because it's ultimately just a stay order, a temporary stay, that does permit the plaintiff to take the case to state court and then return for federal adjudication if necessary. Unless there are any further questions.
Thank you very much, Mr. Ritchie.
Thank you, sir.
Good to have you here. Mr. Reist, I mispronounced your name.
That's okay, or Wiest.
Wiest, Mr. Wiest.
Your Honor, I think it is important to, and I want to just quickly address the standard of review. It is a de novo standard of review on whether or not the Pullman elements are met. Now, if they are met, then it's abuse of discretion. But whether or not the Pullman elements are met is de novo, and that comes out of the Martin v. Stewart case, 499 F3rd 363-65. That's a 2007 case from this court. Our contention is the Pullman elements are not met here. And I want to be clear, there is no unclear issue of state law in terms of the compulsory vaccination law. In fact, I think we just heard that concession. What I heard from my friend was, oh, you've got another remedy. You can bring an EPRA claim, and that might give you relief. And then I turned back to this court's 1983 decision in Educational Services versus Maryland State Board of Education, 710 F. 2nd 170, and this is at 173 of that decision, in which this court said that's not good enough. And let me quote the language. Quote, in this case, however, the only state law questions are ones either not at issue or in effect duplicative of the constitutional claims alleged by the plaintiff. In other words, if you've got a state court remedy, that's not enough to invoke Pullman. There has to be an unclear issue of the challenged law. That's what gets you to Pullman. That's what gets you to an unclear issue of state law presented for decision, which is one of the Pullman elements. And so we do not have anything that's unclear about the compulsory vaccination law. As I've indicated, Judge Bailey, frankly outlined in the first four pages of his decision how it applied and that it was unambiguous. And I want to talk just briefly about the implications of what they are suggesting Pullman requires, which this court has never endorsed. There are state constitutional provisions that people can sue under, a state court challenge. There are other statutes that people could elect remedies to pursue. And what they are in effect saying is, well, hey, if it's a case of first impression, a federal court can abdicate its responsibility and force you into state court to litigate these state court claims that you've elected not to bring. And I want to be clear about the problems that presents when one considers federal constitutional rights. One case I think about is the Bostick case. In Bostick, there was a challenge to same-sex marriage. I think that case came out of North Carolina. Think about it. If the state can go and sit there and point back to the plaintiff and say, you've got a state court remedy and you've got to pursue it. No one will ever be able to vindicate constitutional rights in federal court until they've gone through an entire state court process. And the problem with that is the Supreme Court has indicated that is impermissible. There cannot be any state court exhaustion requirement to vindicate constitutional rights because of the importance of it, whether it's Stuffle v. Thompson, 1974 case, or Nick versus Township of Scott. We have to be able to vindicate constitutional rights in federal court, and it's not enough to sit there and say, you got to go to state court and invoke a separate remedy that you've never elected to pursue so that you can vindicate your federal constitutional rights. Now, it would be different, I think, if the compulsory vaccination law that's being challenged here is ambiguous, if there was a question about its application. That is where typically Pullman has been invoked. And one of the things I wanted to address was Mr. Ritchie's suggestion.
Now, which law are you talking about that's ambiguous?
That we are saying, Your Honor, that the compulsory vaccination law, the requirement, you went through a list of vaccines that are required to attend school
That's
in
the
West
one
Virginia.
you're challenging.
That's the one we're challenging, and that is unambiguous. There is no ambiguity about that.
Was that?
There is no ambiguity in that statute. It is unambiguous.
So which one's ambiguous?
Well, I don't even think the EPRA is ambiguous. I think what they're saying is, hey, if you bring an EPRA claim, you might get relief in state court. In other words, if you pursue a state court remedy, you might get relief in state court.
Well, I think he's also making this claim that it seems like the ERPA, the new state law,
Right.
creates some ambiguity with the CVL. And so that's the ambiguity that gets you under Pullman back into state court.
Yeah, I don't think that that's correct, Your Honor, for this reason. There is an exclusive remedy under the EPRA in which, and this is the subsection B of 35-1A-1, where it indicates that it has to be invoked. And you asked us in supplemental briefing to brief the certification question. Obviously, we thought it was inappropriate to do so, but we did pose a question, a certified law question, which is, number one, does the EPRA even apply if it's not been invoked? Because there's an exclusive remedy under 35-1A-1B to invoke it. And if you've not invoked it, it doesn't apply. It's a state court remedy, which is the problem, and frankly, puts this on all fours with the educational services case out of this court. And so it's not been invoked here. We do not intend to invoke it. Obviously, we've not invoked it in the year or so since Judge Bailey put on his stay order. My clients have no intention to ever invoke it. It's a state court remedy that they're electing, under their election of remedies, not to pursue. I did want to address Mr. Ritchie's discussion of Pullman because I think that it's important. Pullman began with an equal protection challenge. There was this issue in Texas about white conductors and African-American porters, and what Texas, the Railroad Commission, was requiring was to put white conductors on each of the Pullman cars. That was the gist of it. And then there was intervening plaintiffs who said, not only is this unconstitutional under equal protection, because it was, but also they don't have the authority to do this either. So there were plaintiffs before the court that were invoking this state court claim, and what the court said there was, yeah, you know what, this may moot it out, and there are claims that are being brought in that case by intervening plaintiffs. Maybe we can avoid the question because the claims are brought, and so that's why the Pullman abstention doctrine was created. We don't have that here. There's no invocation of the EPRA. We've disclaimed an intention to do so repeatedly, and we've got an unambiguous challenge that's being challenged in a one-count complaint against the First Amendment. And as in Sonda, the application of Pullman abstention here was inappropriate. It's an abuse of discretion, and frankly, it's an error of law because the elements of Pullman are not met, and that issue is reviewed de novo. With that, Your Honor, we would ask that the court reverse, vacate, and remand to Judge Bailey the Pullman order, and then to proceed for further proceedings not inconsistent with the decision. If there's no other questions.
Thank you very much, sir.
Thank you, Your Honor.
Judge Benjamin and I will come down and greet counsel, and we'll go to the next case. In this case, we'll be taking under 5.
All right.
8 years ago as a cutting-edge solar marketplace business. They were going to match providers of solar panels and efficient energy systems to homeowners, and on a national and international basis. Got started in Martinsburg. Over the course of 7 years, they raised in capital, both loans and equity, from $20 to $30 million in performing and in creating this national, international platform to build a solar marketplace right here in West Virginia. And the first, after about 7 years, the company went into bankruptcy. And Mr. Sheehan was first the Chapter 11 trustee, and then the case was converted to a Chapter 7, and he is now the Chapter 7 trustee. He filed a AP against Mr. Levine, who was the former CEO and a director of GeoStellar, on behalf of GeoStellar, for purposes of alleging that Mr. Levine had misdirected the company's resources into a cryptocurrency venture, caused the demise of the corporation, ended it up in bankruptcy, alleging breaches of fiduciary duty, stealing, misappropriation of trade secrets, and various counts of negligence. Now, it turns out that Mr. Sheehan, when he became trustee, purchased the tail, or an extension of the policy of insurance held by GeoStellar, including directors and officers, E&O insurance. So he is the main, GeoStellar is the main insured under this policy. If you look at in the joint appendix, page 169, it has the declarations page. It's GeoStellar who's the insured. And yet, Mr. Levine is also another insured because he is the director or a former director or CEO who's being sued. He's also covered under that policy.
Is the company itself covered under a directors and officers policy?
I'm sorry?
The company, is GeoStellar an insured under the directors and officers policies?
Yes.
I understand directors and officers policies, the insureds are the directors and officers and not the company itself.
Well, that's an issue here, but in fact, under West Virginia law, the owner of the policy, which is GeoStellar, they are the main insured. They, too, are considered what we call a first-party, would be a first-party claimant in terms of seeking a declaratory judgment, which is the issue here that they try to do. But yes, Mr. Levine is essentially another insured, but that doesn't take away GeoStellar being insured. They were insured for the loss of their own director, in other words, caused by their own director. So they're both insureds under the policy.
So you're representing both sides of the case in this adverse proceeding, is that right?
I am? No, I'm representing both trustees. There's
Right, but you're
two
saying that they're adverse to one another in the underlying litigation.
No, their efforts are joint. They're not opposed to each other. And here's what here's how, Judge, we got here. We got here because the district court below determined that they did not have injury or interest enough to grant standing, so we couldn't even reach these underlying issues of first-party, third-party claimant, and yet, to make that determination of no standing, the district court actually made those decisions as to whether or not they were first party. In other words, we said with respect to Mr. Fluharty, and this was the original intent of the declaratory judgment action. First of all, don't get misdirected by the fact there was an injunction requested in that case. That is not before the court. The court denied that. We didn't appeal it. And that had to do with an agreement for early resolution or mediation. But the second count of that declaratory judgment was to say that Mr. Fluharty, by virtue of federal bankruptcy law, 11 U.S.C. Section 541A1, becomes the successor to all property, equitable and legal property interests of the bankrupt. And case law from the fourth...
Bankrupt Levine?
Yes, in the Levine bankruptcy. After we filed suit against Levine, Mr. Sheehan filed suit against Levine on behalf of GeoStellar. Mr. Levine went into bankruptcy. Mr. Fluharty became the trustee in that case. Mr. Fluharty takes the position that he is entitled, under bankruptcy law, to engage in the right to consent to settle. Insurance company says no.
Wait, let me ask you about that, because this order, this mediation order, the Levine trustee says that he is a non-participant in the mediation, the mediation order is what I'm referring to.
Right.
And he represents, and that he's basically, he signs off on this mediation order that I have no interest in this mediation. And so now it sounds like he's saying, well, I do have an interest in this mediation. So that presents a little bit of confusion, because there is a mediation order in which he says, the Levine trustee says that we do not have an interest in the mediation.
Well, if Your Honor will please, I believe that was because he is not a party to the underlying case against Mr. Levine as a trustee. Only Trustee Sheehan is the party. So when the parties mediated the underlying case, that was his way of saying he's not involved in that mediation, which he hasn't been. That doesn't have really, that's a separate question from whether or not he has consent to settle for any particular amount. He's not actively involved in the mediation. He's not actively involved in any way in the underlying. Mr. Fluharty.
Mr. Fluharty.
Right. He just says, all he says, and defendants kind of obfuscate the issue by coming back and say that these two trustees are trying to make a collusive settlement. The right to consent has never, in any insurance policy that I ever heard of, gave the person who has the right to consent control of settlement.
I know, but this mediation order specifically says that the Levine trustee has no interest in the adversary action which does not involve property of the Levine bankruptcy estate. So I'm not understanding how now you're saying that if that's the order before,
right.
How is it now that he's saying that he does have an interest in being able to consent to the settlement?
Well, that's the order you're referring to says he has no interest in that mediation because that's dealing with property of GeoStellar, not Levine. It's a case of GeoStellar against Levine. With respect to the other case that he is expressing an interest in, that's the Levine bankruptcy, and he says he is interested to the extent that all property that was Levine's at the time of the bankruptcy goes to him, including the intangible rights of property to give consent. It's only a question of consent. The trustee in the Levine case has no other interest in that case, has no power to settle that case, and there's nothing, and I would like to see them ask in terms, show me in a policy where that would give control to anyone to settle the case just because they have the right to consent.
You use consent and control differently?
Because they're using it that way, Judge. Yes, it is different. A right to consent under a policy, and it's on page 200, I believe, Joint Appendix 200 of the policy. If you read that, it gives a right to consent. It doesn't, and policies never give the insurer the right to control settlement. It's just a matter of consenting. Even in their brief, the defendants say that he has the right to consent to a reasonable settlement, meaning that they have shifted, they're claiming that Mr. Levine really controls whether or not this case should be settled, even though it has been found he is completely discharged. He has no potential liability in this underlying case. He has no potential liability whether there's an excess verdict or otherwise. He has been discharged completely. And part of the problem was the bankruptcy court kind of misconstrued that. The bankruptcy court below believed that he still had some potential liability, and that's why he should retain this right to consent. He doesn't have any potential.
So, for standing purposes, what is his injury?
I'm sorry?
For standing purposes, what is the injury to the Levine trustee?
Okay, to the Levine trustee,
estate, yes.
it's his, number one, his ability to even file a declaratory judgment action. And insurance companies, as the court knows, file these things routinely because they're first party too. It is routine for first-party claimants, who we think Mr. Fluharty is also, to be able to go to court and have policy provisions ambiguous declared because they resolve things. It would help resolve a case that, by the way, is still going on 5 years later. The underlying case has not settled. And so this is why it's important for first-party claimants to be recognized. Mr. Sheehan, for one, is clearly a first-party claimant, although the court below found he was not. And he's clearly, because if you look at the Loudon
Because
case...
I think the court below said that that he was not, because he is not, he may have bought the D&O policy,
I know.
but that doesn't make him a first party.
That's contrary to West Virginia law. Loudon case that we cited, the Loudon case, Judge, is a case of an insured, Mr. Loudon, suing another insured under the same policy, just like we have here. And that case is directly on point. The West Virginia Supreme Court of Appeals said that in that case, Mr. Loudon is a first-party claimant because he's the owner of the policy. That's the Loudon case. We cite it in our brief.
Lawsuit against...
Right on point. That's West Virginia substantive insurance law. And that's why the court below was wrong. He is a first-party claimant. Mr. Fluharty is a first-party claimant because he has succeeded to all of the property and rights of Mr. Levine.
Counsel?
And he has the right under the authority, well, it's not binding precedent on this court, of course, but the only case we found in the United States, and both sides have looked exhaustively, is the 10th Circuit case of Ole v. Baird that we cite in the case. In Ray Baird is another way of saying it. And that was a 10th Circuit case. Judge Gorsuch was on the three-judge panel at the time. And the court there, it involved a medical malpractice.
Yeah, and in that case, I think his doctor, he bought the policy for himself. So that's why the court said that he would be a first party, because he bought it for himself, if I remember the facts of that correctly. Well, differently here is this policy, D&O policy, I think is what was bought for the benefit of Levine as a director and officer of Geo Stellar, right?
Well, the judge below was wrong about that to this extent. It was bought by Geo Stellar for its own benefit as well as the other insurers.
But counsel, can you hear me?
Oh, I'm sorry, Judge, I'm over my time.
I wanted to follow up on the question.
Question.
Oh, I'm sorry,
She had a
Judge.
question.
I'm sorry, Judge.
Thank you. I want to follow up on the question of Judge Benjamin about coverage. I understand that your assertion that under some circumstances, this policy would cover GeoStellar. But we're not talking about some circumstances. We're talking about in the underlying suit that the GeoStellar has brought against Levine. Are you saying that in that underlying suit, GeoStellar is covered? That's the issue here, is whether GeoStellar is covered in that underlying suit, not if it would be covered in any suit in any circumstance, but in this particular suit, is GeoStellar covered?
If I can answer it this way, the money's not going to come from GeoStellar's insurance policy. It's going to come from the fact that Levine is covered under the policy separately as like an additional insured. However,
But GeoStellar's not a defendant in the suit. GeoStellar is the plaintiff in the suit. So how could GeoStellar be covered as a plaintiff in the suit? And if GeoStellar's not covered, how would then GeoStellar have standing to bring this declaratory action?
a first-party claimant, which GeoStellar is, under the dictates of Loudon, whether or not he's covered, that is a Loudon case. You have to review it, but I believe Loudon stands for the proposition that in a case where an additional insured is the one being sued by the insured, just like here, GeoStellar, that does not make them a third-party claimant. They're still a first-party claimant. They still have the right to insist on a substantive, fair practices of the insurance company, that the insurance company has to act without bad faith with respect to any first-party claimant, not just a third-party claimant, a first-party claimant. That's what springs all the, under West Virginia law, of course, we have banned by statute third-party claimants' ability to sue for damages. Again, the court below kind of mistook this case for that kind of case because they found that Mr. Sheehan was a third-party claimant. He's not a third-party claimant. I say Mr. Sheehan, I really mean GeoStellar, as to whom he really has all the property.
Who would have the right here to make a
Shamblin. That's a good question because that's an issue.
Is that what they call it?
Yeah.
To shamblinize?
Yes.
Who would have that right of these folks?
We believe that both Mr. GeoStellar has that right because they're the ones that are going to get the money for any wrongdoing of Mr. Levine. It's harm to the corporation that he has done. So in that sense, Judge Berner, I think they are covered in that sense. I mean, they're going to be the ones that are in...
Is Shamblin still kind of is that unique in state laws around the country in the principle that Justice Dealey...
It's not so unique, Judge. I think it's another state. I know Ohio has a version of it, just from my own experience. But Shamblin, if you read Shamblin, it talks about the rights of the insured.
Yes.
Insured. That includes Mr. Levine here. That also includes Mr. Sheehan, because he's an insured. I mean, GeoStellar, because they're an insured.
Does it include Fluharty?
I think it does because...
You're saying either one of the trustees could invoke Shamblin.
And Fluharty under the federal law, bankruptcy law.
Which would simply be a demand to settle under the policy limits if you're able to.
Right.
And if you are able to and don't.
Right.
You're basically an insurer for everything in the excess.
But that's not how they're acting. They say we have no right. Yeah.
No, I'm just asking you if that's my statement is a proper understanding.
Yes.
Of what I would call about Shamblin.
Right. Mr. Fluharty, because he got what Levine had under the federal bankruptcy law. Mr. Sheehan, because GeoStellar is an insurer too, under Loudon. So,
are there any facts here that would justify a Shamblin demand?
Well, they have been made.
In this record, or is that speculation?
No, it's happened. And it has for some time. This was in the original mediation, as the court will recall, and it is in the record, there was a question of a refusal to settle, or that Mr. Levine wouldn't mediate, or mediation was going to go, and it was up to him. And then the second time around, as they point out in their brief, they did give a consent to settle, but they say in their brief that the consent was for a reasonable amount. And that's why I think it's important. They also say it's moot now. He's already given consent to settle, Mr. Levine. Well, it doesn't resolve the question of whether or not Fluharty has it in the beginning, but all over and above that, they're still claiming that he somehow exercises control over the amount of settlement, which is nowhere in the policy. It's not a legitimate situation that they are relying on, and they continue to rely upon it in their brief. So, I'm sorry I went over.
Thank you, Mr. Cassidy.
Yeah.
Mr. Grasmick?
I'm getting up there, Your Honor.
Take your time.
Take a moment.
Take your time.
Bring all my toys.
Good to have you here, sir.
Thank you very much, Your Honor. I need one more pile, and then I'm good. Yeah. Oops, that was bad. Is that one important? Yeah. May it please the court. The remarkable thing, Your Honors, is consent to settle is not the issue before the court today. Whether it's first party or third party is not before the court today. Shamblin is not before the court today. This case is up on appeal on a 12B6 motion to dismiss entered in the bankruptcy court. The only issue before this court is, should this case be remanded and should the motion to dismiss be reversed? And motion to dismiss was decided on standing. Consent to settle wasn't decided. Shamblin issues weren't decided. Whether or not Mr. Levine had consented to anything was not decided. What was decided was whether Mr. Fluharty had standing and whether Mr. Sheehan had standing. And those questions are entirely independent. It could be the case Fluharty...
Why does not the fact that they're insured gives them standing? The fact that they're insured under the policy, why doesn't that give them standing?
Well, Your Honor, I'm going to get to them separately because in the case of Mr. Fluharty, his interest is extinguished by the order entered by the bankruptcy court that allows specifically Mr. Sheehan to proceed against Mr. Levine to the limit of insurance only. As we explained in our brief, typically on that type of case, you don't even need to get permission from the bankruptcy for Mr. Levine because the litigation is happening entirely outside the Levine bankruptcy. The litigation presents no financial risk to the Levine bankruptcy because it's only to collect money from an insurance policy that can't be used to pay any other debts in the Levine bankruptcy. The bankruptcy court entered an order, and we have that in the record, and I can read from that order if you would like, Your Honors, that said explicitly the adversarial proceeding with Mr. Sheehan against Mr. Levine may proceed to the limit of insurance only. That's significant. First, that means you can't get a judgment that exceeds the limit of insurance. There can be no threat to Mr. Fluharty's interest because there can be no order entered. Second, that means you can't have an excess judgment that gives rise to any of these bad faith claims because the adversary proceeding can't seek a judgment that exceeds the insurance policy. So the questions you're asking, Your Honor, Judge King, about, well, do we get Shamblin? You can't reach Shamblin because you can enter a verdict in the adversary proceeding, but that verdict can't exceed the policy limit. You can never have an excess judgment. If actually Mr. Sheehan sought an excess judgment, he'd be in contempt. He can't seek that judgment. That's why in the first instance, Mr. Levine's trustee, Mr. Fluharty, cannot have standing because he can't suffer injury. There is no circumstance they can describe where there would be an injury actionable to the Levine estate because the litigation is happening entirely outside that bankruptcy. And the Levine bankruptcy is closed. I mean, all the creditors that could be paid have been paid. There's no more debt. Nothing else is being done. It's entirely fictitious to say the geostellar litigation presents a threat because it can't present a threat. The order allowing that litigation precludes that threat. So your analysis then for Mr. Sheehan is separate. And the standing question there is this. Not is Mr. Sheehan a first-party insured or a third-party insured. It's does Mr. Sheehan have standing to bring a deck action to make Mr. Fluharty the person who consents to settlement? That's the question. The standing question below was that Mr. Sheehan can't show any injury. What is Mr. Sheehan's injury? Because Mr. Fluharty can't give consent. You know, if we were in court below, I probably would have waited a couple of beats to see what they say. But the reality is he can't suffer any injury. Mr. Sheehan today, as he said, is pursuing his arbitration. He can obtain a judgment in arbitration. He can get paid the policy limit if he demonstrates that result in arbitration. The fact that Mr. Fluharty can't settle the case today doesn't mean Mr. Sheehan can't get his judgment in December when the arbitration goes to trial. I mean, that's pretty basic. Failure to get consent is not an injury. Think about that for a second. The issue is standing, not consent, but failure to get consent is not an injury. And they've never demonstrated it's an injury. Now, this circuit has made it clear that you just can't have, standing just because you want standing in a declaratory judgment action. And in fact, this court has said expressly, the Fourth Circuit has said, that in order to have standing in an insurance case, you can't be looking at questions of indemnity. You have to be looking at questions where there is already a judgment entered. And indeed, typically, this circuit has held that you cannot have standing for a declaratory judgment action on a hypothetical basis. Specifically, it was in Trust Guard Insurance v. Collins, 942 F. 3rd 195 at 199. This court has found standing is a jurisdictional issue we must consider independently. The irreducible constitutional minimum of standing requires the petitioner to allege a concrete injury that is actual or imminent, not conceptual or hypothetical. There's no concrete injury to Mr. Sheehan because Mr. Fluharty can't say, I'll settle your case. So what? You can litigate it to judgment and then seek the indemnity. In the same case, in Trust Guard, this court said the suits about duty to indemnify, unlike the duty to defend suits, would ordinarily be advisory when the insured's liability remains undetermined. Any judgment in the deck action that Mr. Fluharty somehow should give consent becomes an advisory opinion because it's purely hypothetical what would go on. What we haven't had before the court is the settlement process as described in the policy. They like to ignore that language. The settlement process requires that Mr. Levine, as an insured, under the A-side coverage of the D&O policy, give consent, and that Philadelphia give consent. So if we're going to have a settlement, Philadelphia has to consent, Levine has to consent, and Mr. Sheehan has to show that he's likely to succeed on some kind of merit. He has to show some reason to consent. And those, again, are all hypotheticals, which is why this circuit has said for a deck action, until you actually have an actual indemnity, there's no standing, because you're just dealing with hypotheticals. You're dealing with pure speculation. And
what about this question, like the question I asked him earlier about GeoStellar, and I think Judge Berner's asking the same question. He's saying that GeoStellar has standing because they are first party interest because their purchase of the insurance policy under a West Virginia case, I think he called it Loudon.
Yeah. Several parts to that answer, Your Honor. That's a great question. The first is he misunderstands the policy completely. There's A-side coverage, B-side coverage, and C-side coverage.
GeoStellar bought the policy.
They're the purchaser of the policy, but they purchased it for the directors. Companies purchase D&O policies to ensure their directors and officers. Otherwise, the officers and directors won't serve. That's why you have A-side, B-side, and C-side coverage. The A-side coverage means GeoStellar bought the policy, Mr. Levine is sued, He's an A-side coverage person. So Philadelphia provides a defense and indemnity to Mr. Levine. Depending on state law and whether or not you can, as GeoStellar, directly indemnify your officers and directors, you go into B-side coverage. B-side coverage, Philadelphia would pay GeoStellar, so GeoStellar could pay Levine. That's not happening here. C-side coverage is GeoStellar is sued under something that they can be sued under the policy. As we explained in our brief, GeoStellar can't be sued here. They're the party bringing the lawsuit. That's why we cited the Allied Signal case that explains under a D&O policy where the trustee for the bankrupt corporation brings the lawsuit, they're a third party. And so the on-point cases that we cite, Allied Signal and that we list in others in the string site, explain very clearly A-side, B-side, C-side coverage are different. And because this is an A-side coverage case, and GeoStellar is the plaintiff, they're not a first party. The Loudon case they want to cite from West Virginia. First, the West Virginia Supreme Court said that case is unique. That's an automobile insurance policy. It's not a D&O policy. The coverage parts are different. The policies are different. In that case, the policy owner got hit by his own car when they were fixing the car because his brother hit him. And so the claimant is the policy owner because in a sense suing to get his auto insurance to pay him. So you can file a first party claim under your own auto insurance, and because his brother is the occasional driver, his brother is getting covered by the insurance policy because brother is suing brother to get paid for injuries under their auto insurance policy. That's not happening with the D&O policy. GeoStellar is not suing itself. GeoStellar is suing its director. And the D&O policy actually has a carve-out that allows that in the case of bankruptcy. Ordinarily, GeoStellar couldn't sue its director. That would be barred by the IVI, the insured versus insured exclusion. There is a carve-out, though, for a bankruptcy trustee. The bankruptcy trustee can bring the lawsuit because the trustee is in part standing in the shoes of GeoStellar, but the bankruptcy trustee is actually standing in the shoes of the creditors. So what happens here is Mr. Sheehan, standing in the shoes of the creditors and sort of for the shareholders of GeoStellar, is suing Mr. Levine. He's not a first-party claimant when he sues Mr. Levine. And the Allied Signal case explains that very, very clearly. You have different roles, and in bankruptcy you have different positions. And in the Allied Signal court, Delaware Bankruptcy Court, a lot of deference to Delaware bankruptcy people. They think a lot about these problems. And the Delaware Bankruptcy Court explained you have to look at the language of the policy, you have to look at the language of the lawsuit, you have to analyze the individual facts. And the question that was put, to counsel at the end about why are they a first-party plaintiff was a great question because they're not. That's a complete misreading of the policy, and it's also a complete misreading of the way the parties are situated. Mr. Sheehan can't settle with... Yes, Your Honor.
Thank you. If the Gramsci case against Mr. Levine settles say it goes to trial and the ultimate outcome is beyond the limits of liability, who has liability for that lawsuit beyond the limits of...
Your Honor, the court order... I'm sorry, Your Honor.
Is that Mr. Levine or is it the Levine estate?
Your Honor, you can't have that result. The order that was entered by the court allowing this litigation, and I quote from the motion, and the order granted the motion that was written, it says, this trustees moves the court for relief from the stay in this case to permit the litigation to proceed to the extent of insurance. And that's in the joint appendix at 1271. That's
right,
all.
but the litigation is stayed above that amount.
No, the litigation's proceeding, and the most the litigation can award is the amount of insurance. They can't seek more. Otherwise, they're in contempt.
Right, at this point, because the bankruptcy is in place, and the bankruptcy court has only lifted the stay up to the limits of liability.
And that's a common occurrence in bankruptcy court, Your Honor. I'm litigating some of those cases elsewhere, and you just litigate within the spread of the order. It's like, playing chess within the rules. I can only move my pawn.
So did liability under this lawsuit move at the time of bankruptcy from Mr. Levine to the estate?
No. It's entirely outside of the estate because you're litigating into standard. We cite a string of cases about this in our brief that Mr. Levine's purpose is really to serve as a marker so you can evaluate the amount of damage the insurance will pay to the plaintiff. It's never been in the bankruptcy estate of Mr. Levine. It's always been outside of it, and it's always been to the limit of insurance because there's a D&O policy that can only pay on a D&O claim outside of the insurance based on Mr. Levine's status as an officer director of GeoStellar, not Mr. Levine as an individual. So the order on allowing the adversarial proceeding is you may proceed to the limit of insurance only. That's a beautiful order. Bankruptcy courts use those all the time, and because that's how you solve all these insoluble problems they're creating. You eliminate the need for the issue of consent because this order presents no threat to the Levine bankruptcy. You eliminate the problem of personal liability. Mr. Levine's liability was discharged by the bankruptcy, so he couldn't be liable. Because you limit the amount of the lawsuit to the insurance, you can't have an excess judgment. So you eliminate the problem of bad faith settlement because you can't have an excess judgment. That's the point of writing the order in the bankruptcy court, that you have an order.
I thought Shamblin meant that the coverage extended to the excess judgment.
Well, Your Honor, Your Honor, it would, but Shamblin didn't apply in the context where the lawsuit.
I don't think it was an insurance, a bankruptcy.
It wasn't a bankruptcy case, Your Honor.
But it said, excuse me.
No, Your Honor, the problem with Shamblin is it's an opposite to this. And it's simply because you can't have an excess judgment here. The judgment here by the order must be within the scope of the limits of the policy.
Shamblin extends the coverage.
No, it doesn't. That would be where you don't have this type of an order. This type of an order says Mr. Sheehan can't seek more. And Shamblin is not dealing with where there's a bankruptcy order limiting what the plaintiff may seek. The plaintiff can be constrained by bankruptcy court orders because that's how you get relief from the automatic stay. Under the automatic, the bankruptcy court said, sorry, you may not proceed in this suit at all. The bankruptcy court said, you have relief from the automatic stay, and you may proceed to the limit of insurance only. That's it. You can't get an excess judgment because there's no money to pay an excess judgment. If you were to have an excess judgment, that would go to Mr. Levine. Mr. Levine's been discharged, so he couldn't pay the excess judgment. There would be an unpaid excess judgment. Shamblin might let you go after an insurance company depending on if you had a settlement, but Shamblin was very specific. In Shamblin, they took out the punitive damages component because they found the insurance company hadn't acted in bad faith. And in Shamblin, they also pointed out the insurance company needs to reasonably conclude that your settlement offer makes sense. It's logical. And in Shamblin, there had been settlement offers, and those went back and forth where they worked. But the insurance company had found in Shamblin that the likely judgment would exceed the policy. That's the reason they ordered payment in Shamblin. You don't have that case here because, in fact, there's no suggestion at all here that Philadelphia's ever made an analysis that any judgment would exceed the value of the policy. And in fact,
isn't there an argument that it's an eroding policy and the cost of defense could exceed the limits of liability and leave nothing for a settlement?
Your Honor, that is an argument. The Allied Signal case talked about that argument and said that's the true any time that you have a D&O policy with eroding limits, and it was the choice of the company to buy that policy because it was a cheaper policy. The district court here and the bankruptcy court here both observed that's just buyer's remorse by Mr. Sheehan because Mr. Sheehan chose to buy a policy with an eroding limit. Instead of extending the policy, Mr. Sheehan could have said, I want to get rid of the eroding limit, and he didn't choose to do that. So he did that to himself. Again, it's speculative if the damages would exceed the defense costs. And I don't want to touch on anything from the confidential arbitration, Your Honors, and so I'm not going to make a record that's not here. I can just say, based on my knowledge of what's been paid out, there's a lot of money left to pay. It's a $3 million policy. Defense costs have not taken that much. There's a substantial amount that could be paid. And so that's why, and there were no factual findings about that, by the way, in the district court or in the bankruptcy court. And that's not the issue on the motion to dismiss. The issue on the motion to dismiss was standing. And the fact that it's an eroding policy wouldn't confer standing on Mr. Sheehan to get Mr. Fluharty to have consent because that's not injury to Mr. Sheehan. I mean, it encourages that you settle now, but settlement requires that you make a reasonable settlement demand. And again, there's no record of the settlement demands made before this court. So we can't even evaluate whether there's some reasonable settlement demands and a reasonable response. That's not the record before the court. The record before the court was that the bankruptcy court found and the district court agreed any suggestion of injury is purely hypothetical. And under Fourth Circuit law, that doesn't give you the basis for standing for a DEC action if you're dealing with the question of indemnity. All speculation. We don't know what the damages will be. They might be zero.
Before you sit down, can you quickly address the issue of the reputational interest that you claim Mr. Levine has in the lawsuit?
Mr. Levine's interest, and I think Allied Signal talks about, his only interest is simply, he doesn't want to be known as a bad person. He would like to be able to say that I didn't cause the failure of the company, and he could get vindicated. And he can get vindicated in two ways. He can get vindicated by winning at trial. I mean, that would vindicate him. But he also can get vindicated by negotiating a good settlement. He can come back and say, I came up with a way to resolve the litigation, and because of that, I was able to protect the interests of the company and everyone, even though I'm not there anymore. My time has ended, Your Honor. If you have no more questions, I thank you.
Judge Barnum?
Thank you.
Thank you, Your Honors.
Thank you very much, sir. Mr. Cassidy?
As Your Honors may expect, we do not agree with counsel's statements that the order of the bankruptcy court limiting collection to insurance would preclude an excess verdict, because as Judge King, you have said, we look at that as an extension of coverage of a policy under West Virginia bad faith law. But that's not an issue before this court. But we disagree with that. The one thing he didn't mention, which is a matter really of bankruptcy law, but they keep claiming there's no possible way of having an excess verdict. GeoStellar has filed a proof of claim against Mr. Levine in his bankruptcy action, even though he has been discharged. In other words, there's creditors there, and they have to be paid and that sort of thing. GeoStellar has filed a proof of claim for any damages in excess of the policy limits be paid to GeoStellar as the harmed party. So that is a legitimate claim in the bankruptcy process, has nothing to do with the automatic stay. That operates by virtue of bankruptcy law. And so that is an interest Mr. Levine has in terms of any excess verdict. And I wanted to bring up, he spent a lot of time distinguishing Loudon. And none of the facts that he gave distinguish the actual syllabus points. And if I can just take a moment, syllabus point 2 of Loudon, of the court, syllabus point 2 of the court. A first-party bad faith action is one wherein the insured sues his own insurer for failing to use good faith in settling a claim filed by an insured. Okay. Number 3, when a named policyholder, like GeoStellar, files a claim with his insurer alleging that a non-named insured under the same policy caused him or her injury, i.e. Levine, the policyholder is a first-party claimant in any subsequent bad faith action against the insurer arising from the handling of the policyholder's claim. It is West Virginia law that the insurance company, so as not to engage in bad faith, do a reasonable investigation of the claim on a timely basis and settle the case when make a reasonable offer settlement when liability has become reasonably clear. This is the duty owed to GeoStellar, not Levine, by Philadelphia. And it is one that Mr. Sheehan and Mr. Trustee, to the extent he got those rights by virtue of federal law, are interested in, because you put your hand on it again, your finger on it again, it's a wasting policy. They say there's only $3 million to begin with. They've been defending it for 5 years. Well, they say there's plenty there. But if the companies, if Philadelphia is gauging in bad faith, have not assumed the risk, letting up the tortfeasor make the decisions about settlement, that is Levine, he doesn't want to settle. He has no skin in the game. He can't be hurt on an excess judgment. But Levine's estate can, by virtue of this proof of claim that was filed by Mr. Trustee, by Mr. Sheehan as trustee of GeoStellar, and Mr. Sheehan's GeoStellar estate can be harmed too by bad faith actions of Philadelphia. That's what this case is about. But in terms of the decisions of the lower courts below, it is a question of standing, we know that, but in saying there was no standing, they actually resolved these issues that they said we weren't even going to get to by saying these gentlemen were not first-party claimants. And that's the problem with the decisions, Your Honor, on standing. And if the court were going to say that the question is moot or something, you would at least have to vacate the lower court's decisions, because this is all, you talk about an advisory opinion, courts all over the lot about whether these guys are third-party plaintiffs, and that wasn't an issue even raised by our declaratory judgment action, but that was the reasoning they came to, and that's why we appealed in saying they had no standing. That's the problem. In any event, we think the harm is real. It's being suffered by GeoStellar right now, to the extent the case is not settled and being cannibalized by the terms of the policy of eroding. And because these trustees of two estates are not allowed, like other first-party claimants all across the country, to seek declaratory judgments against an insurance company as to what it means, the insurance provisions made, because they have been misconstrued to be third-party claimants, or hamper their ability to pursue their rights under substantive West Virginia law to assure that the insurance company treats them fairly and does not breach its duty of good faith and fair dealing. Thank you.
Thank you, Mr. Cassidy. We'll come down and greet counsel and adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.